n'omusango gw'obutemu nga kigambirwa nti ng'ennaku z'omwezi 2 Ogwokuna 2026 eggaba Early Childhood Development Center ng'esangibwa Gaba Christopher Okell Onyum yatta Ejjiku Gideon.
Count 2, murder contrary to sections 171 and 172 of the Penal Code Act. It is alleged that Christopher Okell Onyum, on the 2nd day of April 2026, at Gaba Early Childhood Development Zone, Gaba Parish, marking a division, Kampala District, with murder caused the death of Keisha Agenolo Otim.
Omusango gw'okubiri nagwo gwa butemu nga kigambirwa nti ng'ennaku z'omwezi 2 Ogwokuna 2026 Gaba Childhood Center ng'esangibwa Gaba Machinje Division, Kampala District, Christopher Okell Onyum yatta Keisha Agenworth Otim.
In count 3, it is also murder contrary to sections 171 and 172 of the Penal Code Act, Cap 128, and it is alleged that Christopher Okell Onyum, on the 2nd day of April 2026 at Gaba Early Childhood Development Center, Gaba Trading Zone, Gaba Parish, marking the division, Kampala District, with malice aforethought unlawfully caused the death of Seriange Ignatius.
Omusango gwokusatu nagwo gwa butemu nga kigambirwa nti ng'ennaku z'omwezi 2 Ogwokuna 2026 eggaba Early Childhood Development Center Christopher Okell Onyum ng'alina ekigendererwa yatta Seriange Ignatius.
And count 4, murder contrary to sections 171 and 172 of the Penal Code Act. It is alleged that Christopher Okell Onyum, on the 2nd day of April 2026 at Gaba Early Childhood Development Center, Gaba Trading Zone, Gaba Parish, marking a division, Kampala District, with malice aforethought unlawfully caused the death of Odeke Ryan.
Omusango gw'okuna nagwo gwa butemu nga kigambirwa nti ng'ennaku z'omwezi 2 Ogwokuna 2026 ku Gaba Early Childhood Development Center esangibwa Gaba Machinje Division mu Kampala, Christopher Okell Onyum ng'alibwa yatta Odeke Ryan.
And when this matter came up, the prosecution was represented by Mr. Jonathan Mwaganya and Ms. Anna Kiza, both chief state attorneys for the Director of Public Prosecutions, while the accused person was represented by Mr. Muga Richard and Mr. Oro Sarah on state brief. And on watching brief, we had, on behalf of the families of the deceased children, we had Mr. Stanley Okell, Mr. Roger Mugabi, and Mr. Pius Katumba Usogozi from James Advocates. And I note that both counsel for the accused person and the prosecution made oral submission citing court decisions which I have considered and relied upon this judgment.
Ng'omusango gutandika oludda olwali lwaleeta omuwabi wa gavumenti gwe bayita Mwaganya Jonathan ne Anna Kiza, ate oludda lw'omuwabirwa waliwo Kumbuga Richard ne Sarah Awero ng'abo gavumenti yabawa omuwabirwa, ate nga waliwo balooya bajja olwa famiri z'abaana abaafa. Eyasooka waliwo Stanley, owokubiri Roger Mugabi, owokusatu Pius Katumba, ate nti oluvannyuma lw'okuwulira obujulizi balooya enjuyi zonna baawumbawumba obujulizi ne boogera ne ku mateeka ge bagenderako ate kooti
From the facts of the case as laid before this court, this is what I can be the prosecution case. The deceased persons, namely Ejek Gideon, aged 2 years and 6 months, Keisha Agenoro Otim, aged 1 year and 11 months, Ignatius Seriange, aged 2 years and 4 months, and Odeke Ryan, aged 1 year and 3 months, were under the care of Gaba Early Childhood Development Center, and in this case
lwabi lwaleeta obujulizi okulaga nti abaana bano abana asooka eteku yali wa myaka 2 n'emyezi 6, owokubiri Keisha yali wa mwaka gumu n'emyezi 11, owokusatu Seryange yali wa myaka 2 n'emyezi 4, asembayo Okell yali wa mwaka gumu n'emyezi 3, nga bonna baali mu ssomero lya Gaba Childhood Development Center, ate ajja kusigala ng'akisoma nga center, ate ng'essomero lino liri wansi wa church eya Gaba Community Church nga esangibwa Gaba mu Bachidye Division, Kampala District.
Keisha available to him was female, while the 3 deceased persons were male. The other 3 were male. The center was founded by Gaba Community Church and operates a daycare and an early childhood program for the vulnerable and malnourished children who are identified from the community. The children under the daycare program pay some money, while those ones, the vulnerable, do not pay. Ignitia Seryange, Gideon Eteku were among the vulnerables, while Okell and Keisha again or team were under the daycare program.
Keisha yali mwana muwala, abalala baali balenzi, nga bonna essomero lino yali wansi wa church ya Gaba Community Church, ate nga baali balina daycare ate n'okutuulirawo abaana baali batalina mwanjo nga basangamu daycare baali basasula ate abaalabi balina ku bantu nga tebasasula.
Chanja, where he was residing, to the center, where he met one of the caretakers, Miss Phoebe Namteli, who testified as PW6.
Nti kuva mwezi 3 Mulumu ogwokusatu 2026 muwawabirwa yapangisa emmotoka kika kya lwabufo ng'agenda gyevugira era nga lumu ogwokuna 2026 yavuga okuva Namugera Close Ekyanja gye yali abeera n'atuuka ku ssomero eryo erya center n'asinkana omukyala gwe bayita Phoebe.
And she testified as the prosecution witness number 6.
Ate yajja n'awa obujulizi ng'omujulizi w'omukaaga ku lw'oludda olwabi.
The accused person remained outside the gate, and Miss Namteli went to the gate to find out whether he needed help. And the accused person informed her that he had a child aged 3 years and required an admission for her. He asked for the requirement, was informed, and promised to go and prepare to return and make the necessary payments.
Nti yasigala wabweru wa geeti okutuusa Phoebe lwe yagenda n'amubuuza oba asobola okumuyamba. Bwe yamubuuza n'amuddamu nti yali alina omwana w'emyaka 3 yali ayagala kumuyingiza essomero era n'amubuulira biki byali byetaagisa kwe kugamba nti kugenda yeetegeke akomewo.
The next day, the 2nd of April 2026, at about 11 a.m., the accused person returned to the center, and when Namteli saw him, she went to the gate, and the accused person informed her that he had returned to make the payment as he had promised the previous day. PW6 opened the gate for the accused person and brought him to the office of the coordinator of the center, known as Miss Annette Odong Agoye, who testified as PW7.
Nti nga 2 ogwokuna 2026 ssaawa nga 5 ez'okumakya omuwabirwa yakomawo n'atuuka ku geeti. Phoebe n'amulaba, bwe yamulaba n'amugamba nti yali azi kusasula era n'amugulirawo geeti n'amutwala mu ofiisi yali akulira ssente eyo gwe bayita Annette Adom, era yajja wano okuwa obujulizi ng'omujulizi w'omusanvu ku lw'oludda olwabi.
Miss Namteri introduced the accused to Miss Annette and informed her of their encounter and conversation the previous day. Miss Odong welcomed him and also interviewed him pertaining to the details of the child to be enrolled. The accused person inquired about the requirements and he was informed that he needed to pay a total of Uganda shillings 190,000, which would cover the registration, daycare fees and uniform.
Phoebe yayanjulira omuwabirwa n'amuwanjulira Annette n'amugamba nti baali boogedde ejjo, era oli n'amwaniriza n'amubuuza ebikwata ku mwana gwe yali aleeta, era n'amala n'amubuulira biki byali byetaagisa, n'amugamba nti yali alina okusasula emitwalo 19 nga giriko egy'okumuwandiisa omwana, kuliko ejja daycare ne za uniform.
The accused person, who said he had no cash on him, asked whether he could pay using mobile money, and he did so on the telephone number of Miss Annette.
Nti yagamba yali tatambudde na ssente nkalu, n'asaba nti ssente aziteeke ku mobile money, era n'aziteeka ku mobile money ya Annette.
PW7, that is Annette, asked PW6 to issue the accused person with a receipt, and the same was issued to him, and was receipt number 2958 in the name of Onyum.
Nti Annette kwe kusaba Phoebe nti amuwandiikire risiiti, era n'awandiika risiiti nga yali mu mannya ga Onyum.
The accused then left the office promising to return with the child and the mother on Tuesday the following week, and I take notice that this was the week of Easter and the next working day was Tuesday of the following week.
Nti era yavaawo n'abasuubiza nti agenda kujja n'omwana ne maama w'omwana wiiki eddako olwokubiri, era owekitiibwa omulamuzi alabye nti yali wiiki ya Easter, n'olwekyo olunaku olulala lw'okukola lwali lwakubiri.
The accused person then walked out heading towards the gate as Miss Namteri, who was still in the office of Miss Annette, bent down to keep the receipt booklet in the drawer.
Era yatambula ng'adda ku geeti, Namteri yali asigadde mu ofiisi ng'akyateeka risiiti mu drawer.
At that time, some children were in a compound playing, and as Miss Namteri rose up to look towards the gate so as to go and open for the accused person to exit the center, she saw the accused person bending while holding a child, and she thought that he was beating the child. She ran outside to establish why he was beating the child, only to reach there and find that the accused person, who was holding a knife, had already cut the neck of one child, and this child was Keisha.
Nti bwe yabadde afuluma, abaana abamu baali wabweru nga bazannya, nti era Phoebe bwe yagenda okusituka ng'agamba agenda aggulewo geeti omuwabirwa afulume, n'atunuulira mu ddirisa n'alaba ng'omuwabirwa akuttamye ng'akuta omwana, n'asooka n'alowooza nti oli yali akuba omwana, n'adduka kumubuuza lwaki yali akuba omwana, n'asanga nga yali anakambe ng'amaze okusala Keisha.
And she was lying in a pool of blood, and the accused person at that time was reaching out for another child.
Yali mu kitaba ky'omusaayi, ate omuwabirwa yali agenda ku mwana omulala.
Miss Phoebe asked the accused person why he was cutting the children, and she also threw one of the children's bicycles, which were in the compound, at him to scare him off. The accused person left the child and ran after her, threatening to cut her as well.
Phoebe bwe yamubuuza lwaki yali asala abaana, n'amukanyugira n'akagaali abaana ke bali bazanyisa, n'asooka n'akaleka, n'amugoba n'adduka.
Miss Phoebe ran away from the accused person while making an alarm, but she fell down, and the accused person ran back to the children very fast. And by the time Miss Phoebe returned to prevent or stop him from cutting the children, She found when he had cut the second child, and she again threw a bike at him as he was pursuing the third child.
Nti bwe yamugoba oli n'adduka yadduka ng'akuba emiranga oluvannyuma n'agwa bwe yamala okugwa ono n'addayo mangu n'adda ku baana n'akwata omwana owokubiri n'amusala.
The accused person again ran after Miss Phoebe, and when she fell down he drew the knife threatening to cut her as well.
Nti era n'amukanyugira akabugaala akalala bwe yakamuganyugira oli n'addamu n'amugoba n'adduka era yagenda okulaba ng'akuta omwana omulala.
The accused person then left Miss Phoebe and went back to the children, and when she rose up, she found him cutting the last child, and the last child to be cut was Okell Ryan.
Nti era yamala n'amuleka oli bwe yagwa n'agenda okususuka n'asanga ng'asaza omwana owasembayo ate yali asembayo baali bamuyita Okell Ryan.
At that time, Miss Annette, who also witnessed the cutting of some of the children together with other caretakers, were making alarms which attracted one Cyrus Bukenya, who arrested the accused person. He was joined by Moses, the security guard, Bashir, and Timothy. When he was being arrested, the accused person threw the knife over the chain link fence. The accused was immediately locked up in the guardhouse at the gate to keep him away from the angry crowd which had formed at that time. And upon his arrest, the accused person was found with 2 new knives in his socks, and they were recovered from him.
Nti Annette naye yali alabye nga asala abaana abamu ne keyateeka omulala eyaliwo baakuba enduulu era bwe baakuba enduulu Cyrus Bukenya, Moses eyali omukuumi, Bashir ne Timothy bajja bwe bamala okujja oli n'abalaba n'asuula akambe n'akasuula wabweru wa geeti era ne bamukwata ne bamugayira mu kayumba ak'omukuumi nga bamutaasa abantu abaali batandise okujja era bwe bamukwata ne basanga nga yali alina obwambe bubiri bupya mu stockings ze.
3 of the attacked children, namely Eteku Gideon, Tisha Ageno Roto Tim, and Ignitia Seryangi, were rushed to Wensi Medical Center, which is about 300 meters away from the center, hoping to save their lives. However, they were pronounced dead on arrival.
Abaana abasatu Eteku, Keisha ne Seryange baabatwala ku ddwaliro lya Wensi Medical Center nga balowooza bayinza okubataasa naye bwe baatuuka ne bagamba nti bali bafudde.
Ryan Odeke, who was clearly dead, was left at the veranda but was also later taken to Wensi Medical Center by police.
Ryan Odeke eyali asigadde naye nga yali afudde baali bamulese ku kabalaza naye oluvannyuma naye baamutwala ku ddwaliro lya Wensi.
The dead bodies of the 4 children were then taken to Mulago, Kampala Capital City Mortuary by police, and post-mortem examinations were done on them by Dr. Katongole Abdul, who described the injuries on all the bodies of the 4 children to have been on the necks, and concluded that the cause of death for the 4 children was hypovolemic shock due to deep cut wounds, deep cut injuries to the neck.
Nti emirambo gino oluvannyuma bagitwala e Mulago mu ggwanika era omusawo gwe bayita Katongole n'akebera emirambo n'annyonnyola nti bonna baali balina obuvunne mu bulago ate n'agamba nti ekyabaviirako okufa baabafumita nnyo ne bavaamu omusaayi mungi.
The police officers from Kabalagala Division of Police visited the center, which they termed as the primary scene of crime, and recovered the killer knife and the 2 other knives and a backpack which was also recovered on the accused person, picked some suspected blood from the compound, among others.
Nti abasirikale ba poliisi e Kabalagala bagenda mu kifo ekyo we battira abaana ne baggyayo obwambe bwe basangawo ne bawugyayo n'ensawo omuwaabi gye yali alina era ne batwalako n'omusaayi gwali mu luggya.
The samples recovered were subjected to DNA analysis and the report was admitted in evidence.
Nti omusaayi ogwo batwala ne bagukebera era ebyava mu kukebera babireeta ng'obujulizi.
The police officers also removed the accused person from the guardhouse at the center amidst the angry crowd which desired to lynch him and they took him to Kabalagala police station.
Omuwawaabirwa bamujja mu kayumba k'omukuumi era ne bamukuuma abantu abaali batuusawo nga bagala kumutta ne bamutwala ku poliisi e Kabalagala.
On 3rd April 2026, the accused person led the investigating team to his house, which he had rented in Sanja at Namugera Close, Katumba Zone. A search was conducted in the accused's house, and a number of items were recovered, which included electronic devices, 2 laptops, 2 mobile phones, and 3 hard drives, which were subjected to forensic analysis, and the digital analysis report was also admitted as evidence.
Nga 3 Ogwokuna 2026 omuwawaabirwa yakulemberamu abali banoonyereza omusango guno n'abatwala mu nnyumba ye gye yali apangisa ekyanja era bwe bayingira ennyumba ne bajjamu ebintu nga laptop 2, amasimu n'ebintu ebirala.
The other items recovered were 2 American passports, a driver's license from the state of Virginia, a sanity report dated 30th December 2025, and 5 new knives, among others.
Nti ebintu ebirala bye bajjamu passports 2 eza America, bajjamu driving permit, ne bajjamu obwambe 5, ne bajjamu ne report gye bali bamuwandiikidde okuva mu ddwaliro nga bagamba omutwe gwe gwali gukola bulungi.
The accused was examined on police form 24 by Dr. Emmanuel Nwamanya, who testified as PW11, and he was found to be mentally normal. It was upon that background that the accused was indicted for murder in 4 counts, hence this case.
Nti omuwawaabirwa bamutwala ne bamukebera, ate yamukebera yali musawo gwe bayita Emmanuel Nwamanya, era yajjanga omujulizi w'oludda olwali ow'okumi oluvannyuma ne bamuteekako emisango 4 gya butemu.
The accused person gave an unsworn statement and called 2 witnesses in his defense. He had mentioned 4 witnesses but provided only the telephone numbers but without any physical address. Only 2 witnesses were reached using the telephone numbers provided by the accused person, and efforts to trace the 2 were futile because the phone numbers were not on.
Nti omuwawaabirwa yayogera nga talayidde era n'aleeta abajulizi 2. Yali asabye okuleeta abajulizi 4 naye nga tataddeeko wa gye baali babeera, n'ateekako amasimu gaabwe gokka. Okukuba amasimu 2 be basobola okujja, 2 amasimu gaabwe gaali tegaliiko.
It is important to note here that one of the 2 numbers that he had provided that could not be reached was an American number.
Naye tulina okumanya nti mu masimu ago 2 emu yali ya America.
In his defense, the accused person did not deny killing the 4 children, but stated that he did not act intentionally or deliberately.
Mu kwewozaako teyagaana nti omusango teyagukola, wabula yagamba nti teyagukola mu bugenderere.
He stated that although there were claims that he was completely mentally okay, there may have been other mental challenges that may have gone undetected and could have contributed to the death of the children.
Agamba nti wadde bagamba nti omutwe gwe gwali gukola bulungi, naye wayinza okubaawo ebintu ebirala bye bataalaba okulaga nti biyinza okuba nga bye byamuviirako okutta abaana abo.
He said he was not mentally okay, and he also denied being foul-minded in the killing of the children.
Agamba nti omutwe gwe gwali tegukola bulungi era agamba nti si yeeyagalira okutta abaana bano.
In respect to this, he referred to the book about war, which was part of the evidence of PW18, the digital analyst, who analyzed his flash disk and found that he had saved a book entitled The Art of War by Sun Tzu. The accused person stated that he saved that file long before, and it cannot be said to apply to the killing of the children.
Nti waliwo ekitabo omujulizi ow'okumi-na-mukaaga ow'oludda olwabiri yayogera omujulizi ow'okumi-na-munaana yayogera ku kitabo ky'olutalo era n'agamba nti ono yali yakiteeka ku flash ye n'agamba nti ekyo kitabo yali yakiteekako edda tekisobola kubeera nga kyekyaviirako okutta abaana bano.
He also denied being deliberate and with forethought while making reference to the prosecution evidence of PW 18, which revealed that using his phone, the accused person had made Google searches on subjects including ISIS beheading and for schools that teach young children. He said that although these searches suggest that he did it deliberately, there were factors that forced him to conduct them.
Nti ye yagaana ekyokugamba nti abaana bano yabatta nga kigenderedde n'agamba nti omujulizi ow'okumunana yagamba nti yakozesa essimu ye okukebera ebikwata ku ekitongole ekitema emitwe gy'abantu ekibayita ISIS ng'anoonyereza ku masomero g'abaana abato n'agamba nti
he said that although these searches suggest that he did it deliberately, there were other factors that forced him to conduct those searches.
Nti wadde bagamba nti bino bye byanoonyerezaako ebyamuleetera okutta abaana abo waliwo ebintu ebirala ebyamuleetera okutta abaana.
During his testimony, the accused person further stated that he was under the control of some people whom he occasionally called friends, and that they fell into three categories. He stated that between January and March 2026, he entered an especially distressing period because he was contending with some people who were surveilling him, making many demands of him, and threatening to kill him. They began demanding money, and he noticed that they had all the capabilities. As a result, he left the Bunga neighborhood where he was staying and began sleeping on the streets.
Nti omuwawaabirwa yagamba nti bino byonna yabikola olw'ensonga nti waliwo abantu be yali ng'alaba engeri ssatu be yannyonnyolako n'agamba nti wakati wa January n'omwezi ogwokusatu yali mu kiseera ky'okwennyamira era ng'agamba abantu abo bamusabanga ebintu bingi ne bamusaba ssente ne bamugamba nti bagenda kumutta era n'ava mu kitundu kye yali abeeramu n'agenda n'atandika okubeera ku luguudo.
He stated that because of this, he tried to end it some way and somehow, and according to him, he tried several things to bring the whole thing to an end, including fleeing the country, robbing a bank, and killing his brother's family. He then concluded by saying that those said people whose names he chose not to disclose to the court influenced his actions of the 2nd of April 2026. He concluded his testimony by inviting the court not to honor the charges for murder against him because there were some circumstances that forced him to act the way he did on 2nd April 2026, and this is the date of the unfortunate incident.
Nti yatuuka ekiseera ng'ayagala kubikomeekereza n'agezaako okwagala kuva mu ggwanga n'agezaako okubba bbanka era n'agezaako n'okutta famire ya muganda we n'agamba nti abantu abo batayogera mu kooti be bamuviirako okutta abaana abo oba bye byamuviirako ebyo byatuukawo nga 2 Ogwokuna 2026.
Okay, there is a burden and standard of proof. This is known. The prosecution bears the burden to prove all the ingredients of the offense, or in 4 counts beyond reasonable doubt, and I will skip that and I go to the ingredients of the offense of murder.
Lwabiro lulina obuvunaanyizibwa okuleeta obujulizi obumala.
Section 171 of the Penal Code Act, Chapter 128, which defines the offense of murder, provides that any person who, with malice aforethought, causes the death of another person by an unlawful act or omission commits murder.
Nti amateeka gagamba nti omuntu yenna ng'alina ekigendererwa n'atta omuntu mu bumenyi bw'amateeka aba attemudde omuntu.
For the accused person to be convicted of murder, the prosecution must prove each of the following essential ingredients beyond reasonable doubt. 1, death of a human being, that the death was caused by some unlawful act, that the unlawful act was actuated by malice aforethought, and that it is the accused person who caused the unlawful act of death.
Nti oludda olwabi lulina okuleeta obujulizi okukakasa nti mu butuufu waliwo okufa, nti okufa okwo kwali kumenya amateeka, nti ate okufa okwo nti yakukola yali alina ekigendererwa, era abalina okuleeta obujulizi nga bulaga nti omuntu ali mu kooti ye yazza emisango gino.
I will discuss all the 4 counts together because they are supported by the same evidence. However, the third ingredient of the unlawful act being actuated by malice aforethought shall be addressed last.
Nti emisango gyonna ajja kugyogerako omulundi gumu okuggyako ekigendererwa kyagenda okwogerako kyokka nga kyawukanye n'ebiri.
And I will do it last.
Kyagenda okusembyayo.
Death of a human being or human beings. Death may be proved by production of a postmortem report or evidence of witnesses who state that they knew the deceased and attended the burial also the dead body. And in the instant case, the fact that the infants, Eteku, Gideon, Keisha, Ageno Roth, or Tim, Ignatius, Seriang, and Odeke Ryan are dead is not in dispute. And in proof of this, the prosecution adduced the evidence of Dr. Katongole Abdul, who performed the postmortem examinations on the bodies of the 4 children, and he confirmed that they were dead. The parents of these children, namely Apollo Stella is the mother of Eteku Gideon, Komakech Marvin is the father of Keisha, and Bazia Rollins is the father of Seriange, and Okrutu Simon is the father of Ryan Odeke. They all confirmed that their children died and they were buried.
Ekikulaga okufa basobola okulabira ku baluwa omusawo gy'awandiika nga amaze okukebera emirambo, obujulizi bw'abantu abali bamanyi abantu bano ate ne babaziika. Bagamba nti Eteku, Keisha, Seriange ne Odeke okufa kwabwe bonna tebakuwakanya, kubanga omusawo gwe bayita Katongole yakola ripooti ng'akakasa nti abaana bano baafa, ate n'abazadde b'abaana bonna bajja ne bawa obujulizi ne bakakasa nti abaana bano baafa.
Also, the evidence of one of the caretakers, Miss Namteri Phoebe, and the coordinator of the center, Miss Aneta Goye, who were the eyewitnesses to the attack on the children that resulted in their death, also confirmed that they are dead. And the prosecution also adduced the evidence of the divisional CID officer, Kabalagala, called Esserite James. He testified as CW15, and the scenes of crimes officer, he testified as CW14. They testified that they saw the bodies of the 4 children.
Nti Phoebe ne Annette be baaliwo nga balaba omuwawabirwa ng'asala abaana abo ne kibaviirako okufa, era bajja mu kooti ne bakakasa nti abaana baali bafudde, era ne baleeta abajulizi ow'15 n'ow'14. Ow'15 yakulira okunoonyereza emisango mu Kabalagala, ne baleeta n'oyagenda gye bakoledde emisango, era ne bakakasa nti bwe baatuuka mu kifo ekyo balaba abaana abo nga bafudde.
Having considered the evidence and in agreement with the joint opinion of the 3 assessors, I find that the prosecution has proved beyond reasonable doubt that the 4 infants, namely Eteku Gideon, Keisha Ageno Roth Tim, Seriang Ignatius, and Odeke Ryan are dead.
Okusinziira ku bujulizi akaanyiza ne ba assessor bwe bagambye nga bagamba nti abaana bana Eteku, Keisha, Seriange ne Odeke baafa.
Also, the fact that the death was unlawful is also not disputed, given the account of the eyewitnesses to the offense and the nature of the injuries on the bodies of the 4 children.
Ekyokugamba nti oba baafa mu bumenyi bw'amateeka nakyo tebakiwakanya olw'ensonga nti waliwo obujulizi bw'abo abaaliwo ne balaba ate n'ebiwundu abaana be babasanga nabyo.
And having considered the evidence and in agreement with the joint opinion of the 3 assessors, I find that the prosecution has also proved this ingredient beyond reasonable doubt, that Eteku Gideon, Keisha Ageno Roth, Tim, Seriang Ignatius, and Odeke Ryan, their death was caused by an unlawful act.
n'olwekyo oweekitiibwa omulamuzi akanyiza ne ba asesa bwe bamuwabula nga bagamba nti Etteku, Keisha, Seruyange ne Odeke nti mu kufa kwabwe kwali kumenya amateeka n'olwekyo obujulizi bumala okulaga nti mu butuufu abaana bano baafa mu bumenyi bw'amateeka.
The participation of the accused person, in order to prove participation, there should be credible, direct or circumstantial evidence placing the accused person at the scene of the crime as an active participant in the commission of the offense.
Ekyokulaga nti oba omuwawali bali mu kooti eyaza omusango balina okuleeta obujulizi obulaga nti omuntu ono yeyatta abantu bano obuliwo oba obujulizi obwetoolodde embeera ezaaliwo.
And in the instant case that the participation of the accused person is not contested because the accused person himself did not deny having killed these children.
Nti mu musango guno ekyokubanga yeyatta abaana omuwawabirwa takiwakanisa.
I will proceed to also to look at the evidence that the prosecution produced to support the fact that it was the accused person who killed these 4 children. The offense occurred in broad daylight, specifically at 11 a.m. or thereabouts. The accounts of the eyewitnesses to the crime, namely Miss Phoebe Namtevi and Miss Annette Odong Agoye, the caretaker and coordinator respectively, revealed that the accused person with whom they had just been interacting in the office of Miss Annette was seen gruesomely and brutally cutting the 4 children with a sharp knife, which he threw out of the chain link fence upon seeing the first responders to the scene.
Nti kooti egenda kutunuulira obujulizi oludda olwabi bwe bwaleeta era n'agamba nti ebintu bino byaliwo emisana zaali ssaawa 5 ez'okumakya nti ate waliwo abajulizi abaaliwo ne balaba nga Phoebe ne Annette ng'abo bona bakolera essomero eryo ate ne bagamba nti omuwawabirwa baali boogera naye era nga yali yakafuluma era ne bamulaba nga asala abaana abo oluvannyuma n'asuula akambe wabweru w'eggeeti.
The prosecution further adduced the evidence of the scenes of crimes officer, Mr. Mutaka Jim, his PW14, and SRI James, the lead investigator, PW15, who testified to the effect that they responded and went to the center, which they referred to as the primary scene, and they found that the accused person had already been arrested by the first responders and was being kept in the guardhouse to keep him away from the angry mob that wanted to lynch him. PW15 SRI James then rearrested him and took him to Kawalagala police station.
Nti baleeta omujulizi ow'okumi-na-bana ng'oyo yagenda mu bifo gye bazzaamu emisango bamuyita Mutaka Jim era ne baleeta n'omujulizi owa-15 yeyo yakulira ebyokunoonyereza emisango ku poliisi y'e Kawalagala era nti badduka ne batuuka mu kifo ekyo bwe baatuuka ne basanga omuwawabirwa baali bamaze okumukwata nga bamuterese mu kayumba k'omukuumi nga bamutaasa ku bantu abaali baagala kumukuba era oluvannyuma omujulizi owa-15 n'addamu n'amukwata n'amutwala ku poliisi.
The prosecution also adduced forensic evidence that implicates the accused person by placing him at the scene of the crime, namely the evidence of AIP Odongo Emmanuel. He's a CCTV analyst, and he testified that police CCTV cameras on the roads and some private CCTV cameras showed that a motor vehicle RAV4 was seen being driven from Chanja, where the accused person was residing, through Nakawa until it reached Renewal Circle in Gaba, where it was captured by the private camera of Renewal Circle on 1st April 2026.
Era baleeta obujulizi obulala obw'abakakensa ne baleeta omuserikale gwe bayita AIP Odongo Emmanuel ng'ono yeekebejja zi CCTV kamera oba kamera ez'oku kkubo era n'agamba nti mu kwekebeja yalaba emmotoka ekika kya RAV4 nga bagivuga kuva ekyanja bayita Nakawa ne batuuka ku Renewal Circle era ne kamera ya ku Renewal Circle n'emukwata nga lumu ogwokuna 2006.
And this court takes judicial notice that the Renewal Circle, which is part of the Gawa Community Church Complex, is directly behind the center.
Ate kooti eraba nti Renewal Circle nayo eri kumpi ne kanisa ya Gawa Community Church ate eri kumpi n'essomero lino.
Upon parking the motor vehicle in the parking yard of Renewal Circle, the accused person was seen alighting from the vehicle and walking towards the center. This corroborates the evidence of PW6 Miss Phoebe, who testified that the accused person had come to the center on the 1st of April 2026 and had approached the gate of the center on foot. The accused person remained at the gate from where he had a conversation with PW6 regarding the requirements for enrolling his child at the center.
Ntera bagamba nti bwe yapakinga ku Renewal Circle yatambula n'agenda ku ssomero eryo era kino kyongereza ku bujulizi bwa Phoebe eyagamba nti nga lumu ogwokuna 2026 nti omuwawaabirwa yatambuliza ebigere n'atuuka ku geeti era ne boogera wamu ng'amubuuza biki ebyali byetaagisa okuleeta omwana.
The CCTV analysis report also reveals the accused person being ridden on a border on the day of the incident, 2nd April 2026, at 10:16:13. That is 10 o'clock, 16 minutes after 10 and 13 seconds. And he was carrying a black backpack.
Era ripooti eyo eyazi kamera egamba nti omuwawaabirwa baamulaba ku lunaku olwo lwennyini ng'ali ku booda ng'azaali ssaawa 4:16 n'obusekenduzi 13 ng'ali yeetisse akasawo akaddugavu akasawo ak'oku mugongo.
While in court, the witness, who was PW13, played the footage and the images which clearly confirmed the movement of the motor vehicle on the 1st of April 2026 and the border carrying the accused person on 2nd April 2026.
Era bwe baleeta ow'e13 yazireeta ne bakakasa engeri emmotoka ekika kya RAV4 yatambulamu nga lumu ogwokuna 2026 era ne balaga ne booda bwe yatambula ng'emuleese nga 2 ogwokuna 2026.
Whereas the defense counsel during his submissions claimed that the images were not clear, it is not true because the accused person could be clearly identified when he alighted the vehicle at Renewal Circle on 1st April 2026 and also while on a border on 2nd of April 2026.
Nti oludda olwawaabirwa abalooya bagamba nti ebifaananyi byali tebirabika bulungi naye baali si batuufu kubanga baamulaba bulungi ne bamwetegereza bwe yapaakinga ku Renewal Circle nga lumu ogwokuna 2026 era ne baddamu ne bamulaba ng'ali ku booda nga 2 ogwokuna 2026.
The prosecution had earlier on adduced the evidence of PW8 is called Hashim Juma, one of the directors of Trip Car Rental Uganda, who testified that the motor vehicle belongs to his company and the accused had hired it from him to be used on the 1st and 2nd of April 2026 on self-drive. Nti baleeta omujulizi ow'omunaana nga bamuyita Hashim Juma ono yali yapangisa omuwawaabirwa emmotoka ekika kya RAV4 yali yakozesebwa nga lumu n'olunaku z'omwezi 2 ogwokuna 2026 nga yali agenda gyevugira. However, the accused person used the motor vehicle only on 1st April 2026 because it got mechanical defects. This testimony was corroborated by the CCTV evidence where the accused person was seen in the footage of 1st April 2026 pushing the vehicle at Shell Kitgum House, Ginger Road at 2 p.m. with the assistance of the staff of Shell.
nti emotoka yagikozesa nga lumu ogwokuna 2026 wokka kubanga yamala nefuna ebizibu era kino kyongerezebwako obujulizi ono yaleeta obujulizi bwa kamera ng'agamba bamulaba ng'asindika eno emotoka ku Shell Kitgum House Jinja Road zaali ssaawa 8 ez'emisana nga bakola ku Shell be bamuyambako okugisindika.
The accused had earlier on called Hashim and told him about the politica, and Hashim had advised him to park it at Shell Kitgum House.
Nti yali yakuzidde Hashim n'amugamba nti emotoka yali efunye obuzibu era n'amugamba nti agipaakinge ku Shell ya Kitgum House.
In the footage of 2nd April 2026, the accused could be easily identified putting on a checkered black, white, and grey shirt and black sunglasses when he was on a border.
Nti ku katambi ke baaleeta ng'akaali ka 2 ogwokuna 2026 omuwawaabirwa baamulaba bulungi ne bamutegeera kubanga yali ayambadde yali ayambadde esaati y'ebikuubo ate nga yali ayambadde ne galubindi.
And this is corroborated by the evidence of the SOCO, that is the scenes of crimes officer, and the investigator who recovered the said sunglasses stained with blood at the primary scene and took the said shirt from the accused person upon his arrest and submitted both items for the DNA analysis.
Kino kyongereza ku bujulizi bw'oyo omupoliisi agenda mu bifo byebazizaamu emisango kubanga bwe yatuuka mu kifo ekyo n'asanga galubindi ezaaliko omusaayi n'aziggyayo era n'amugyako n'esaati eyo n'abisindika mu beekebeja ebintu ebyo.
The DNA analysis revealed that the cuttings from the shirt contained the DNA of the accused person, while the sunglasses, which were stained with blood, had mixed DNA of both the accused person and of Keisha again Roth, whose body had been labeled as body 39 by the scenes of crimes officer.
Nti mu ndagabutonde bwe baakebera essaati gye bajja ku muvunaanibwa baagikebera nga yaliko ondagabutondo ye era ne baakebera ne galubindi ne basanga nti waliwo endagabutonde ya omuwawaabirwa neya Keisha ate nga Keisha omulambo gwe baali bagutaddeko namba 39.
Prosecution also adduced evidence that the accused person was cutting the children with a knife, which he threw over the chain link fence upon seeing the first responders at the scene. The knife was recovered by the scenes of crimes officer. It was a kitchen knife with a silver handle and black blade with the label reading Ming Feng. And while at the laboratory, a swab from the knife handle was taken, and also a swab from the blade was taken. And it was established that the handle had a male DNA profile which belonged to the accused person.
Nti obujulizi bwonna bugamba nti yali abaana bano nga basaza akambe era abantu bwe batandika okujja akambe n'akasuula wabweru wa geeti akambe kano kaliko ebigambo Ming Feng nti bwe baamala akambe ako ne bakatwala okukeekebeja bwe baamala okukeekebeja ne basanga nga waliwo endagabutonde z'omuwawaabirwa.
Also, the blood stains on the blade of the knife were for body 3 and body 37. And body 3 was for Odeke Ryan, while body 37 was for Seriange Ignatius.
Nti era ne akambe bakajjako omusaayi gwaliko ne bagenda kukeekebeja ne basangako endagamutonde za Ryan ne Seriange.
Whereas the accused in his defense did not deny the killing of the children, the defense, this defense will be discussed at length while discussing the last ingredient.
Nti wadde omuwawaabirwa teyeegaana ekyokutta abaana abo naye ensonga ye gye yawaayo oweekitiibwa omulamuzi agenda kugyogerako.
During the submissions of counsel for the accused person attempted to suggest that the accused person was not adequately implicated for the offense, and his argument was based on the fact that whereas PW6 and PW7 testified that they were first the accused person and kept him in the guardhouse, none of those persons
bawumba obujulizi lawyer w'omuwaabirwa yagamba nti oludda lwabi lwalemererwa okuleeta obujulizi obumala okukakasa nti omuwaabirwa ye yaza omusango guno, nti ng'agamba nti waliwo abantu abasooka okujja nga Cyrus ne Moses naye tebabaleeta mu kooti, naye ne yeebuuza poliisi yamusangawa okumukwata.
I note that whereas it was prudent to have one of those witnesses to come to court, failure to have them did not affect the prosecution evidence. At least PW6 and PW7, that is Phoebe and Annette, testified that they saw the accused person being apprehended and being kept in the guardhouse, and PW15 and PW14, that is the investigator, the lead investigator, and the SOCO, the scenes of crimes officer, they confirmed finding the accused person having been arrested and kept in the guardhouse. That evidence was not challenged at all in cross-examination, and in light of all the other evidence placing the accused person at the primary scene of crime, it is my finding that the accused, that the evidence that the accused was apprehended in the act of slaughtering the children, kept in the guardhouse and later picked up by police is true.
Ntera bagamba omuntu omulamuzi agamba kituufu abana abantu abasooka okujja bandize mu kooti ne bawa obujulizi, naye ne bwe baba nga tebaze kubanga Phoebe ne Annette bajja ne bawa obujulizi ne bagamba nti baaliwo era ne balaba nti bamukwata ne bamutereka mu kayumba k'omukuumi, era waliwo obujulizi obulala bw'omujulizi ow'14 ne ow'15 era bajja ne bagamba nti basanga ng'omuwawaabirwa bamaze okumukwata ne bamutereka mu kayumba k'omukuumi. N'olwekyo kusinziira ku bujulizi Oweekitiibwa omulamuzi agamba kituufu omuwawaabirwa bamukwatirawo ng'akola omusango ogwo era ne bamukwata ne bamutereka mu kayumba k'omukuumi.
In light of the above, it is the finding of this court and in agreement with the joint opinion of the assessors that the prosecution has proved beyond reasonable doubt that the accused person caused the death of the 4 children, namely Eteku Gideon, Keisha Agenrofo Tim, Seriange Ignatius, and Odeke Ryan.
N'olwekyo Oweekitiibwa omulamuzi akkanyiza ne ba assessor bwe bamuwabula nga bagamba nti oludda olwabi luleese obujulizi obumala okulaga nti mu butuufu abaana bano Eteku, Keisha, Seriange ne Odeke baafa.
I will go to the last ingredient, and that is the ingredient of malice aforethought.
Kati agenda kwogera ku ky'okugamba nti eyatta abaana bano yali alina ekigendererwa.
Malice aforethought is defined in section 174 of the Penal Code Act. And the summary of it is that malice aforethought shall be deemed to be established by evidence provided for by the following circumstances. An intention to cause the death of any person, whether that person is the person actually killed or not. B, knowledge that the act or omission causing death will probably cause the death of some person, whether that person is the person actually killed or not, although the knowledge is accompanied by indifference, whether death is caused or not, or by a wish that it may not be caused. In summary, that you must have had an intention to kill somebody, or you had knowledge that your act or your failure to act would actually result into the death of a person.
Ekigendererwa ekitabo ky'ebibonerezo akawayiro 17 kigamba nti obujulizi bulina okulaga nti wali olina ekigendererwa okutta omuntu ne bw'oba nga okoseke wali oyagala kutta, olina okubeera ng'omanyi nti bino byonna by'oli mu kukola birina okuviirako okufa kw'omuntu. Ebikulu kiri nti olina okuba ng'omanyi nti byonna by'ogenda okukola biyinza okuviirako omuntu okufa.
So malice aforethought is a mental element. and this is not easy to prove with direct evidence. But inferences may be made from a number of things, including the nature of the weapon used, the parts of the body targeted, the nature of injury, and the conduct of the accused person before, during, and after the commission of the offense.
Dimba yakbe yadi Shirivan Sirode. Yeah. Driver ngoja. Driver ziko kali. Toa gari. Driver toa gari.
Aggressively and gruesomely cut the necks of the 4 children with a knife.
Ese mola. Bwana hii mwele masako azida driver ni azikuyo. Driver kono chungu na toka na unajua ni riski sana, tawezi nguka chini. Kama naongeza na tupo mpaka chini hapo. Nafikiri ya mchezo. Wewe utaweza kuonekana ndani huko. Kama ukufe huko ndani huko. Afadhali kama nafika hapa iko mzuri sasa. Sasa alikuwa mbaya, hii ndio hii. Asongeze hizi mawe karibu hapo. Okay.
Confusion, and the wound was deep, transecting through the esophagus, trachea.
Dimba yakbe yadi Shirivan Sirode. Yeah. Driver ngoja. Driver ziko kali. Toa gari. Driver toa gari. Ranji. Ini.
ekiwundu kyali kiwanvu nnyo nga kiyita mu mubiri ne kisala emisuwa egisinga egy'obulago.
And he concluded, or he noted, that these findings were consistent with deep cut wounds.
Era n'agamba nti ebiwundu ebyo byaliwo olw'ensonga nti baamufumita nnyo.
Seriang Ignatius was said to have had a 14 centimeter long open wound on the right side of the neck, which was longer than it was deep.
Seriange naye yali alina ekiwundu nga kyali kya sentimita 14 ate nga bali bamusaze nnyo.
The wound was deep, transecting through the skin and underlying neck muscles, injuring the internal jugular vein.
Nti ekiwundu kyali kiwanvu nga kisala ne kiyingira ne kisayira ddala emisuwa gy'obulago.
He found that the above descriptions were consistent with deep cut injuries.
Era n'agamba nti ekiwundu kino kyajja olw'ensonga nti baamusala nnyo n'afuna obuvune.
This one also had another 4 centimeter long cut wound located on the right submandibular region. We go to Okell, Ryan, the last child. This one was said to have had a 9 centimeter long deep cut wound located on the right side of the neck. It was a deep cut wound dissecting through the underlying neck muscles, neck vessels, trachea, esophagus, and transection of a spinal cord. The cause of death for all the children was established to be hypovolemic shock due to cut wounds to the neck.
Okell naye yali alina ekiwundu nga kyali kya sentimita 9 nga kirina ku kkono ly'obulago era ekiwundu kino kyali kiwanvu nnyo nga kisalira ddala emisuwa egisinga egy'obulago nga kigendera ddala ku nkizi. N'agamba nti kyaviirako omwana ono okufa, baamusala nnyo n'avaamu omusaayi mungi.
All the postmortem reports for the 4 children were admitted and marked as exhibits 1, 2, 3, and 4 respectively.
Alipoota z'omusawo ze yakeberako abaana bano banna zonna baazireeta mu kooti ng'ebizibiti ekisooka, ekyokubiri, ekyokusatu n'ekyokuna.
This evidence is further corroborated by the evidence of the scene of crimes officer, Mr. Mutaka Jimmy, who visited the primary scene of crime. This is the center. Immediately after the commission of the crime, he processed it and made a report which was admitted as PEX-10. And this is what he said, that at the center, he found the body of an infant on the veranda, and it was identified to him as that of Okell. And he uniquely marked that body as 3. On this body, he observed one deep cut injury on the right side of the neck, with cuttings through the neck bones and muscles. And he took pictures of this body, and they are in his report on page 11 and 12.
Nti kino kyongerezebwako obujulizi bwa soko oba omupoliisi agenda mu bifo bye bazizaamu omusango bamuyita Mutaka Jimmy. Era yagamba nti yagirawo mu kifo ekyo n'awandiika alipoota gye baleeta ng'ekizibiro ky'okkumi. N'agamba bwe yatuuka mu kifo ekyo yasanga omwana omuto, omulambo gw'omwana omuto eyali ku kabalaza nga bali bamuyita Ryan, n'aguteekako namba 3. N'agamba nti omulambo guno gwali gulina ekiwundu ekinene ku bulago, ng'ekiwundu kino kyali kisala amagumba n'emisuwa egy'obulago. Era n'akuba ebifaananyi n'abiteeka mu alipoota eyo.
Shortly thereafter, he went to Wenzi Medical Center, this is the secondary scene, where he found the bodies of the 3 children, and they were identified to him as Eteku Gideon, he uniquely labeled his body number 32, Seriang Ignatius number 37, and Keisha Ageno Roth's team was labeled 39.
Omupoliisi oyo yayongera n'agenda ku Wenzi Medical Center bwe yatuukayo ne bamulaga emirambo gy'abaana abasatu, Eteku n'amuteekako namba 32, Seryange n'amuteekako namba 37 ne Keisha n'amuteekako namba 39.
PW14, this is the scenes of crimes officer, further testified that all presented similar fresh injuries of deep cuts on the right side of the neck, which went from the muscle and bones.
N'agamba nti abaana bano baali balina ebiwundu bye
This court also observed the photographs of the bodies of the 4 infants and confirmed the gruesomeness of the attack on all of them as evidenced by the nature of the injuries.
Era kooti yatunulira ebifaananyi by'abaana abo n'ekakasa engeri abaana gye baafaamu baafa bubi.
The murder weapon, which is a knife, which caused those grave and fatal injuries on the children, was also recovered at the primary scene of crime just behind a chain link fence after being thrown by the accused person, and it was also admitted as evidence.
Nti era n'ekisi akambe baakafuna nga baali baakasuula wabweru ya geeti ne bakaleeta mu kooti ng'ekizibiti.
So we have those grave injuries and the knife that caused them.
Tulina ebiwundu ebyali ebibe ennyo n'akambe akaakozesebwa.
The above evidence would be sufficient to prove Marisa for fault because there would be no other inference that a person pounces on defenseless, innocent babies and goes ahead to cut their necks as if slaughtering a goat or a chicken in that accurate and precise manner other than that of Marisa for fault.
Nti era ku bujulizi obwo bulina okuba nga bumala kubanga omuntu tasobola kugenda n'akwata obwana obuto nga teweesobola n'abusala obulago ng'asala embuzi oba enkoko.
However, the defense heavily contested this ingredient and insisted that the accused person was not in a right state of mind to form an intention to commit the offense of murder.
Nti oludda olw'omwawabirwa balooya be bagamba nti ebyo si bituufu kubanga nti omwawabirwa omutwe gwe gwali tegukola bulungi n'olwekyo yali tasobola kutemula.
The accused person in his unsworn statement stated that he did not act intentionally or deliberately, and although there were claims that he was completely mentally okay, there may have been other mental challenges that may have gone undetected, which could have contributed to the death of the children. He insisted he was not mentally okay.
Nti bwe yali ayewozaako teyalayira naye n'agamba nti ye kino teyakikola mu bugenderere, n'agamba wadde nti bagamba nti omutwe gwe gwali gukola bulungi naye bayinza okubawo ebintu ebirala bye bataategeera ebiyinza okuba nga byamuviirako okukola ebyo bye yakola, n'akakasizza ensonga egamba nti ye omutwe gwe tegukola bulungi. Omutwe gwe gwali tegukola bulungi.
The accused also denied being fair-minded in the killing of the children, and in respect to this, he made reference to the book. I already talked about that, but this is for emphasis. That the flash disk which showed that he had done a search and saved a book on the art of war. He stated that he did it long ago and it had nothing to do with the death of the children.
Nti era agamba nti ekino ekintu kyonna teyakiteekateeka ekyokutta abaana, n'agamba nti ekyokuteeka akatabo k'entalo n'okunoonyereza byonna bye yanoonyereza agamba nti akatabo yakanoonyerezako ebiseera by'emabega nnyo tebiyinza okuba nga byo byamuviirako okutta abaana abo.
He also denied being deliberate and with forethought while making reference to the evidence of the Google searches that he made using his phone, specifically the search for ISIS beheading and for schools that teach young children. And he said that whereas these searches may suggest that he did it deliberately, there were other factors forcing him to make those searches, which factors he chose not to disclose to the court.
Nti era yagamba nti ye teyabikola mu bugenderere era n'agamba nti bino bye yanoonyerezaako ku mukutu ng'ebya ISIS okuggyako emitwe amasomero agasomesa abaana abato nti naye waliwo ebintu ebirala ebyamuleetera okunoonyereza ku bintu ebyo.
You have not also interpreted the factors, those factors he did not disclose to the court.
Nti ebintu ebirala ebyamuleetera okunoonyereza ku bintu ebyo teyabibuulira kooti.
The accused person further stated that he was under the control of some people whom he occasionally referred to as friends and were in three categories.
Nti yagamba nti yali akola olw'ensonga y'abantu be yali ayita mikwano gye ate nga bali bangeri busatu.
He also alluded to the fact that between January 2026 and March 2026, he entered into a distressing period because he was contending with some people who were surveilling him, making demands from him, and they threatened to kill him.
Nti yagamba nti wakati w'omwezi gwa January n'ogwokusatu 2026 yali mwenyamuvu nnyo olw'abantu be yali abali bamusumbuwa era nga agamba abali bamutambulirako era kyekyamuviirako okukola ebintu bino.
They began, according to him, they began demanding for money, and he noticed that they had all the capabilities and they were following him closely. And as a result, he left his the neighborhood of Bunga, where he was staying, and resorted to sleeping on the streets.
Nti baali bamusaba ssente era nga yalaba nga baali balina obusobozi nga bamugoberera nnyo kyekyamuleetera kuva Bunga gye yali abeera n'agenda n'atandika kubeera ku luguudo.
The accused person stated that as a result of this, he tried to end it somewhere and somehow, so as to bring the whole thing to an end. And according to him, he tried to flee the country, tried to rob a bank, and tried to kill his brother's family. He then said that those people whom he at times referred to as his friends during his testimony had something to do with his actions of 2nd April 2026.
Nti yatuuka ekiseera n'ayagala kikomenkereza n'asalawo ave mu ggwanga n'agezaako okubba banka n'agezaako okutta famire ya muganda we n'agamba nti abantu abo be baali balina kye balina ku kyatuukawo nga 2026.
He invited the court not to honor the charges of murder because there were some circumstances that forced him to act the way he did on 2nd of April.
N'asaba koti ereme okumusingisa omusango ogw'obutemu ng'agamba waliwo ensonga ezamuleetera okukola bye yakola nga 2 Ogwokuna 2026.
Unfortunately, he neither stated the circumstances he claimed forced him to act that way, nor did he disclose the identities of his friends who may have compelled his actions on 2nd April 2026.
Nti byembi teyayogera biki ebyamuleetera okukola ebintu ebyo bye yakola nga 2 Ogwokuna 2026.
No, he did not state the circumstances, and he also did not disclose the identities of those friends of his.
Nti ebintu ebyo ebyamuleetera okukola bye yakola ate n'amanya oba okwogera baani abamuleetera okukola ebyo bye yakola 2 Ogwokuna 2026 teyabyogera eri kooti.
And because he made an unfortunate statement in his defense, he could not be probed to give more information.
Olw'ensonga nti teyalayira ng'awa obujulizi baali tebasobola kumubuuza ebibuuzo bingi ku kino.
By the above claim, the accused raised a defense of insanity.
Olw'ekyo yagamba nti ye omutwe gwe gwali tegukola bulungi mu kaseera ako.
The defense of insanity is provided for under Section 11 of the Penal Code Act, Chapter 128.
nti ekyokugamba nti omuntu omutwe guba tegukola bulungi ekitabo kya bibonerezo kikyogerako mu kawayiro ka 11.
And this is what it provides, that a person is not criminally responsible for an act or omission if at the time of doing the act or making the omission, he or she is through any disease affecting his or her mind incapable of understanding what he or she is doing, or knowing that he or she ought not to do the act or omission, although his or her mind is affected by disease, if that disease does not in fact produce upon his or her mind one or other of the effects mentioned in this section in reference to that act or omission. I will summarize this to mean that the accused, somebody must show that he had a disease of the mind, and as a result of the disease of the mind, he was incapable of knowing the nature and quality of his actions at the time when that action is said to have been done. That is summary of this law.
Nti etteeka lino mu bufunze ligamba nti omuntu alina okukakasa nti yali alina obulwadde bw'obwongo, nti ate okubeera n'obulwadde obwo nti yali tasobola kumanya ebikolwa bye yali akola kye bitegeeza oba ekiyinza okumuviira mu bikolwa by'akoze.
So if it is found that actually he had a disease of mind, and that disease of mind made him incapable of understanding what he was doing and what its consequences would be, that would be a total defense to him.
Nti bw'agamba nti yali alina obulwadde bw'obwongo nga tasobola kutegeera biki bye yali akola, awo aba yeewoozezzaako.
And for the offense of insanity to stand, the accused person must satisfy the ground set out under the Magna-Carta rule. And the test is purely cognitive, and the defense must show whether the accused understood his or her actions or that his or her actions were wrong. The defense of insanity is twofold. First, that an insane defendant does not have control over his or her conduct, similar to somebody who is sleepwalking, not knowing what they're doing. And secondly, that the defendant does not have the ability to form a criminal intent. Without the ability to control conduct or the understanding that conduct is evil or wrong by society standards, an insane person or defendant presumably will commit crimes again and again. This person must not be in control of anything to do with himself. He cannot control his actions because of the disease of the mind. These rules require that the three tests should be proved. One, that an individual suffers from a defect of reason, which is caused by a disease of the mind, and that as a result, he or she does not know the nature and quality of his act, or that that act is wrong. And when somebody raises a defense of insanity, when he says I was not normal, like the accused person said that he was not mentally okay, then it becomes his responsibility to prove to the court that actually that was the condition that he was in at the time the offense was committed.
nti omuntu okugamba nti omutwe gwe gwali tegukola bulungi alina okukakasa kooti nti yali tasobola kutegeera ebintu byali akola oba byali bituufu oba byali bikyamu oba byali si bikyamu nti alina okulaga nti yali tamanyi biki byali bigenda mu maaso n'ebintu bye yali akola abeera ng'omuntu atambula ekiro nga yeebase nga tategeera biki ebigenda mu maaso n'agamba nti omuntu bw'atyo aba tasobola kubeera mu mutwe nga ateekateeka ekintu okukola ekintu ekikyamu kubanga aba tasobola kumanya ekikyamu oba ekituufu n'agamba nti aba tasobola kwesalirawo biki byakola olw'ensonga nti alina obulwadde bw'obwongo.
The defense of insanity seeks to do away with an essential requirement of malice aforethought, and it seeks to prove that the accused person did not have the intention to cause death, neither did he have knowledge that such an act or omission would cause the death. And this is because of the presumption of sanity, which is provided for in Section 10 of the Penal Code Act.
Nti okugamba nti omuntu omutwe gwe gwali gulina obulwadde baba baagala okugjako ekyokugamba nti omuntu yalina ekigendererwa okutta abantu naye
there is a presumption of sanity.
Naye waliwo amateeka agagogera ku ky'omuntu okubeera nga omutwe gukola bulungi.
And it provides, in Section 10, it provides that every person is presumed to be of sound mind and to have been of sound mind at any time which comes in question until the contrary is proved.
Era etteeka kawayiro ka 10 kagamba nti buli muntu yenna bamutwala nti omutwe gwe gukola bulungi oba talina bulwadde bw'obwongo okutuusa nga baleese obujulizi okulaga nti mu butuufu omuntu oyo akaseera ako omutwe gwe gwali tegukola bulungi.
This presumption of sanity puts the burden on anyone who claims insanity as a defense to prove that he or she was not in the right mental state at the time of the act or omission.
Kino kiraga nti omuntu agamba nti omutwe gwe gwali mulwadde oba ng'alina obulwadde bw'obwongo alina okuleeta obujulizi okukakasa nti akaseera ako omutwe gwe gwali tegukola bulungi oba yali alina obulwadde bw'obwongo.
And I have already said that when anyone advances the defense of insanity, he bears the burden to prove it, though not on as a higher standard as the prosecution has to prove the case against him beyond reasonable doubt.
Era nga bwe yagambye nti omuntu bw'agamba nti yali alina obulwadde bw'obwongo yalina okuleeta obujulizi okukakasa nti mu butuufu yali alina obulwadde bw'obwongo mu kaseera ako.
I have cited a number of cases which can be found in the judgment. Having laid down the above principles from the law and the decided cases, I will proceed to evaluate the evidence adduced by the accused person in a bid to prove the claim or the defense of insanity.
No,
I have said having laid down the above principles from the law and the decided cases on the defense of insanity.
Oweekitiibwa omulamuzi ng'amaze okwogera ku mateeka agakwata ku ky'okugamba nti omuntu omutwe gwe amateeka n'emisango emirala egyayogerwako ku bulwadde bw'obwongo kati agenda kutunuulira obujulizi bwe baleeta obukwata ku bulwadde bw'obwongo.
I will need to establish whether the accused person was suffering from the disease of the mind at the time the offense was committed, whether that disease of the mind rendered him incapable of knowing the nature and quality of his actions, and whether he knew or did not know that what he was doing was wrong by reason of that disease of mind.
Kooti erina okutunuulira oba omuntu omuwawaabirwa yali alina obulwadde bw'obwongo akaseera ako ate alina okukakasa nti akaseera ako omuwawaabirwa yali tasobola kumanya nti bye yali akola byali bikyamu oba bituufu ate alina okulaba oba yali amanyi nti byonna bye yali akola byali bikyamu oba bituufu.
As a result of the disease of the mind.
Olw'ensonga y'obulwadde bw'obwongo.
From the onset, I need to state that the accused person was the only one who testified that on 2nd April 2026, when he committed this heinous crime, he was not mentally okay.
Nti okuva omuwawaabirwa ye yekka eyawadde obujulizi okugamba nti ku lunaku olwo nga 2 Ogwokuna 2026 nti omutwe gwe gwali si mulungi, tategeera bulungi.
As already indicated, he did not state what he was suffering from, apart from the claim that he was under immense stress from the period between January to March 2026, as a result of the people whom he occasionally referred to as his friends.
Nti yayogera kiki kyali kimuluma okuggyako okugamba nti wakati w'omwezi ogwa January okutuusa Ogwokusatu nti yali mwennyamivu ng'alina abantu byayogerako nga nti bali mikwano gye.
But like I already mentioned, he chose to conceal the identities of those people from court.
Naye yasalawo n'akweka amannya g'abantu abo n'atagabuulira kooti.
I will note at this point that I keenly observed the accused person as he gave his evidence, and I could see that he was withholding some information.
Nti era ng'awa obujulizi nga yeewozaako kooti yamutunuulira n'eraba nti waliwo ebintu byali akweka kooti.
Especially when it came to disclosing the names of those people.
Naddala okwogera ku mannya g'abantu abo be yayogerako.
Apart from this claim, there is no other evidence that was adduced by the accused person in a bid to prove the existence of the disease of the mind, availing the defense of insanity.
Nd'okuggyako ekyo tewali bujulizi bulala obwaleetebwa okulaga nti omuwawaabirwa yali alina obulwadde bw'obwongo.
Counsel for the accused person vehemently argued that the prosecution failed to prove that on 2nd April 2026, when the offense was committed, the accused was not under the influence of mental illness.
Nti era ne bagamba nti oludda olwabi lwademererwa okuleeta obujulizi obulaga nti nga 2 Ogwokuna 2026 nti omuwawaabirwa yali ng'omutwe gwe gukola bulungi.
With all due respect, this argument was not legally backed and was misguided because when the accused person chose to raise insanity as his defense, the burden to prove that insanity shifted to him in light of the presumption of sanity under Section 10 of the Penal Code Act, Cap 128.
Nti omulooya w'omuwawaabirwa yalimbamu kubanga omuntu bw'agamba nti omutwe gwe tegukola bulungi yalina okuleeta obujulizi okulaga nti mutuufu omutwe gwe tegukola bulungi.
Counsel for the accused person further insisted that there was evidence on record from the prosecution provided by Dr. Nwamanya Emmanuel, who testifies as witness number 11. He's a police surgeon and is also a psychiatrist who examined the accused person on the 7th of April 2026, showing that the accused person has ever been admitted to Tarika Mental Hospital. That was his argument. He insisted that prosecution witness said that the accused person had ever been to Tarika.
N'alemerako n'agamba nti obujulizi baali babuleese mu kooti ng'omusawo gwe bayita Nuwagaba Emmanuel yakebera omuwawaabirwa nga 7 Ogwokuna 2026 ate n'agamba nti yali abaddeko mu ddwaliro e Butabika.
Regarding this evidence, I will need to provide context so it is not used to mislead the court. The evidence of PW 11 as contained in PF 24 and in his oral testimony in court is that he examined the accused person on 7th April 2026 and on his psychiatric and mental assessment of the accused person, he found the following, and I will quote verbatim. He had normal behavior, calm, cooperative, speech was coherent, his memory intact, and he exhibited good judgment. His thought process and content was normal, but believed in wealth by human sacrifice. He was able to explain the reason for killing the children as fortune hunting or enrichment. He got the idea on recalling childhood folk tales of getting wealth by sacrificing people.
Nti omujulizi ow'okumi n'omu yawandika alipoota mu kizibiti kye baleeta mu kooti n'obujulizi bwe n'agamba nti omuwawabirwa yamukebera nga 7/4/2026 era bwe yali amwekebejja obwongo yagamba nga bwe yawandiika nti yali yeeyisa bulungi nga mukkakamu ng'akwatagana naye bulungi ng'ayogera bulungi ng'ajjukira bulungi byonna bye yali ayogera. N'agamba nti ate yali asobola na kusalawo bulungi n'agamba nti naye yali akkiririza nnyo mu by'okusaddaaka n'agamba nti ensonga lwaki yatta abaana abo yali anoonya bya bugagga n'agamba nti ekyo yakijja mu ngero ze bamugambanga ng'akyali muto.
In that report, Dr. Nwamanya made the following note as information from the accused during the assessment, and I'm also quoting it verbatim. He had a history of past mental illness, treated between 2016 to 2025 for schizophrenia associated with both auditory and visual hallucinations. He killed his 2 to 3-year-old brother in 2016 or 2017, reportedly to save him from the troubles of this world. He also attempted suicide in 2023, and he was also a sickle cell patient on treatment. The findings above are suggestive of a mental condition with psychotic episodes. Further mental assessment is necessary since no medical documents were availed and he was the only source of information.
Era n'agamba nti omuwawabirwa yamugamba nti eddako yali mulwadde w'omutwe era ne bamujjanjaba nga wakati wa 2016 kutuuka 2025 yali alina obulwadde bw'obwongo nga ye asobola kulaba n'okuwulira ebintu abalala bye batalaba. N'agamba nti yatta muganda we nga 2017 ng'ayagala kwewonya ebizibu by'ensi. N'agamba nti n'agezaako okwetta nga 2023 n'agamba nti yali mulwadde wa nalubiri oba sickle cell. N'agamba nti naye baali beetagisa okuddamu okumukebera olw'ensonga nti yali talina biwandiiko ebikakasa nti yali alina obulwadde bw'obwongo.
From the above, the word Butabika is not mentioned anywhere. Besides the accused person, as he gave his evidence, never at all mentioned having ever been admitted in Butabika Mental Hospital.
Nti mu byonna omusawo bye yawandiika teyawandiika mu kigambo obutabika ate n'omuwawabirwa nga yeewozaako teyayogerako nti bali bamutaddeko mu ddwaliro ebutabika.
It is important to note that the only witness in the entire trial who made mention of Butabika was DW2, whose identity has been concealed for his protection, but he's a biological elder brother to the accused person.
Nti omujulizi yayogera ku butabika ye omujulizi yali wa muwawabirwa ow'okubiri.
The only witness.
Omujulizi yekka eyayogera ku butabika ye omujulizi omujulizi w'okubiri w'omuwawabirwa nga n'amannya ge baagakweka olw'ebyokwerinda bye era nga yali mukulu we.
He testified that in January 2022, he learned that the accused person was in a Butabika Mental Hospital, and when he went to inquire about the reasons for his admission there, he was informed by the in-charge of the hospital that the case under which he was admitted in the facility was very sensitive and declined to avail any information.
N'agamba nti mu January 2022 yawulira
2020, January 2020.
Nti mu January 2022 yawulira nti muganda we yali mu ddwaliro ebutabika era yagendayo bwe yagezaako okubuuza ebyali bikwata ku muganda we ne bamugamba nti ebyo tebasobola kubyogerako era tebaali basobola kumuwa byonna ebikwata ku muntu oyo.
The case under which he was admitted was very sensitive.
Ne bagamba nti omusango oba engeri gye bamuleese mu ddwaliro ebyo baali tebasobola kubyogerako.
He further stated that His father stated during cross-examination that he left without knowing why the accused person had been admitted in Butarika, despite having disclosed to the in-charge that the accused was his young brother.
Era yagamba nti yatuuka okuva e Butarika nga tamanyi kyekyali kikwata ku muganda we wadde nga yali amaze okubagamba nti yali mukulu we.
However, during the cross-examination of DW2, that is the brother of the accused person, the prosecution had an explanation for the accused admission in Butarika at that time, which they put to the witness. And according to them, the accused had murdered his young half-brother called Freeman, and to escape criminal culpability, he was taken to Butarika Mental Hospital to disguise as if he killed the child due to mental illness. And from there, he was whisked to the United States of America, where he stayed until sometime in 2025, when he returned to Uganda.
Nti arudda olwabi baali babuuza omujulizi w'omuwaabi owokubiri bamubuuza nga bamugamba nti yali Butarika olw'ensonga nti yali asse muganda we gwe bayita Freeman, era ne bamutwala Butarika nga bagamba nti omutwe gwe gwali tegukola bulungi. Bwe baatuuka e Butarika ne bamugjayo ne bamutwala Amerika, era bwe yatuuka Amerika n'abeerayo okutuusa 2025.
I find this proposition credible because if indeed the accused person had been admitted because of a medical condition, there would have been no justification for concealing that from his own brother. Besides, they would not have informed him that the case under which the accused person was admitted was very sensitive.
Nti era ekyo kkooti eraba nti kyo kyali kituufu kubanga engeri gye yali agenze e Butarika
it is credible. It can be believed.
Basobola okukkiriza kubanga bwe yagenda e Butarika baali tebalina nsonga yonna lwaki tebamugamba ebyali bikwata ku muganda we, ate ne bamugamba nti omusango gwali gumuleeseza mu ddwaliro eryo byali tebasobola kubyogerako.
The accused person himself would have mentioned that he had never been admitted in Butarika, either to the police surgeon, Dr. Nwamanya, or Dr. Roger Agenda, who testified as PW12 and he's a psychiatrist at CCare International Hospital, Kampala.
Kino muwawaabirwa yennyini yali asobola kwogera nti yali agenzeeko e Butarika ng'agamba Nwamanya Emmanuel oba Agenda Roger wa IHK.
Agenda Roger examined the accused person on 30th December 2025 at the request of the accused person for a sanity assessment, but the accused person did not inform him that he had ever been to Butarika.
Nti Agenda Roger yakebera muwawaabirwa nga 3/12/2025 ng'amukebera oba alina obulwadde bw'omutwe, era bwe yali amukebera teyamugambako nti yali agenzeeko mu ddwaliro ly'e Butarika.
To the contrary, the accused person informed Dr. Agenda Roger that the consultation with him, which is 30th December, was his index of first consultation with a psychiatrist in his whole life, and I will discuss the evidence of Agenda in detail later.
Omuwawaabirwa yagamba nti bwe yagenda ewa Agenda nga 3/12/2025 yamugamba nti gwali mulundi gwe gwali gusookera ddala okubeera ng'ayogera n'omusawo ajanjaba obwongo.
I also need to observe that though DW2 is the biological brother of the accused person, though they are brothers, he testified that they don't closely relate and he had not seen the accused person in the last 5 years, but only saw him at Kabalagala police station after his arrest in respect of this case.
Era omujulizi w'okubiri ow'omuwawaabirwa yali muganda we naye bali siba mikwano nnyo, bali bamaze emyaka 5 nga tebeeraba, bayaddamu okumulaba ku Kabalagala poliisi nga bamaze okumukwata.
He also did not testify to knowing the accused person to suffer from any mental illness.
Era teyayogera nti yali amanyi oba muganda we yali alina obulwadde bw'obwongo.
In the absence of any medical evidence to support the claim of insanity, this court would have expected at least evidence from a family member of the accused person to speak to his alleged mental illness.
Engeri gye waali nga tewali biwandiiko by'abasawo okukakasa nti yali alina obulwadde bw'obwongo, waakiri aba famire oba b'ekika kye bandize ne bawa obujulizi nga boogera ku nsonga eyo ey'obulwadde bw'omutwe.
The brother of the accused person informed the court that he shares both parents with the accused person and they are both still alive and they live in Uganda.
Muganda we yagamba nti babazaala wamu abazadde bombi be bamu ate bakyaliwo babeera mu Uganda.
If it was true that indeed the accused person suffers from any disease of the mind, either his father or mother would have been eager to come to this court to relay that information with some evidence.
Nti singa kyali kituufu nti yali alina obulwadde bw'obwongo, waakiri taata we oba maama we yandize mu kooti n'ayogera ku nsonga eyo.
It is also important to note that the details of the witnesses who came to testify for the defense were furnished by the accused himself, but he chose not to call any of his parents as his witnesses, who would have been better placed to testify to the claim of insanity and or any other disease of the mind.
Nti abajulizi abajja omwawabirwa yeyagamba be yayagala naye teyasaba nti bamuyitire abazadde be ate nga bandize ne bannyonnyola ensonga eno ey'obulwadde bw'obwongo.
Considering the above, I would still proceed to pose this question. Supposing it was indeed true that the accused person has ever been in Butabika in 2020, as stated by his brother, of what relevance would it be in relation to this offense, which is alleged to have been committed on 2nd April 2026, given the legal principles regarding the defense of insanity, that the disease of the mind must be present at the time of the commission of the offense and must have prevented one from knowing what he or she is doing and that what she is doing is wrong.
Era kooti yeebuuziza nti singa kyali kituufu nti mu 2020 omwawabirwa yaliko mu ddwaliro ly'e Butabika, kikwataganira wano omusango guno ogwaliwo nga 2/2/2026. Era n'adda mu mateeka n'agamba nti balina okulaga nti obulwadde obwo bwaliwo akaseera ke yakolera ekintu kino, ate nti mu kaseera ako yali tasobola kutegeera nti kyeyali akola kyali kikyamu oba si kikyamu.
It is my considered view that in the absence of any evidence that the accused person was suffering from the disease of the mind as at the time of commission of this offense, his being admitted in Butabika in 2020 would not be of any relevance to this case.
Olw'okubeera nti tewali bujulizi obulaga nti yali alina obulwadde bw'obwongo, ekyokugamba nti bali bamutadde mu ddwaliro e Butabika tekikwatagana mu musango guno.
I also need to know that in regard to the issue surrounding the admission in Butabika, that shortly it happened, I need to know that in regard to the issue surrounding the admission in Butabika, shortly into the evidence of DW2, the brother of the accused person, when he mentioned the word Butabika, counsel for the accused person made an application seeking for the orders of this court to order some doctors from Butabika to come and confirm that the accused person has ever been in Butabika, and also confirm that he is incapable, or to establish whether he was capable to follow the proceedings. But this was after he had given his defense.
Nti era n'atunuulira embeera ze bamutwaliramu mu ddwaliro e Butabika, era n'agamba nti omujulizi owokubiri ku lw'oludda lw'omuwabirwa nti bwe yayogera ku kigambo Butabika, looya w'omuwabirwa n'agambirawo nti bayite abasawo okuva Butabika okukakasa nti omuwabirwa yali tasobola kugoberera ebyali bigenda mu kooti, naye bye yabisaba ng'omuwabirwa amaze okuwa obujulizi.
I did not find calling anyone from Butabika relevant to this case, and I declined to grant that prayer, and I made a detailed ruling which is on record.
Nti teyalaba bwetaavu okuyita omusawo okuva butabika era yabuwandiika ku fayiro.
In a further bid to support the claim of being mentally unwell due to the distress said to have been between January and March 2026, the accused person testified that he abandoned his home in Bunga and started living on the street. And to prove this defense, he abused the evidence of DW3, whose identities were also withheld for his security. And he informed the court that he was 25 years old, living on the street, and he had seen the accused person only twice while he was in Chisenyi, together with 40 children, aged between 7 and 10 years, and then his age.
Nti omuwawaabirwa yagamba nti yali mu kiseera eky'okwenyamira wakati wa January n'ogwokusatu 2026 nti kyamuleetera okuva gye yali abeera ebbunga n'atandika okubeera ku kkubo n'amala n'aleeta omujulizi ow'okusatu era amannya ge tetujja googera olw'ebyokwerinda bye, naye yagamba nti yali wa myaka 25 egy'obukulu nga yali abeera ku luguudo. N'agamba nti yali alabyeko omuwawaabirwa emirundi 2 gyokka nga bali Kisenyi era nga yali alina abaana abalala 4 nga baali ba myaka wakati wa 7 ne 10, abamu nga bali mu myaka gye.
Okay, I'll summarize his evidence. He testified that he saw the accused went to Chisenyi, and when the street children saw him, they requested for some water to drink, and he offered them food, which he actually paid for. And as he was leaving, he requested the witness for his contact, and they shared contact numbers. And the next time, he came with water in a 10-liter jerrycan and gave it to the witness with the other children. That is the summary of his evidence.
Nti omujulizi ono yajja n'agamba nti omuwawaabirwa yajjako mu Kisenyi ne bamusaba amazzi g'okunywa, mu kifo ky'okubawa amazzi g'okunywa n'abagulira emmere n'asasula. Bwe yali avaawo n'asaba ennamba y'essimu y'omujulizi ono, n'agamba nti olwaddako yajja nga alina akadomola ka lita 10 kalimu amazzi n'agawa omujulizi ono n'abaana abalala.
And he told him that the reason he wanted his telephone contact is that whenever he would need the children, he would help him to gather the children.
N'amugamba nti ensonga lwaki yali ayagala enamba ye y'essimu, yali ayagala nti bw'aba ayagala abaana ono amuyambeko okubakungaanyiza wamu.
Counsel for the accused person, while relying on the claim of being on the street, submitted and said that it is not possible for a normal person to leave their home and start living on the street. But this court finds that there was no evidence that actually the accused person has ever lived on the street. He only went twice to these children in Chisenyi.
Nti looya w'omuwawaabirwa yagamba nti tekisoboka omuntu omulamu okutandika okuva ewuwe waka n'atandika okubeera ku kkubo, naye Oweekitiibwa omulamuzi agamba tewali bujulizi obulaga nti yali abeera ku kkubo, wabula yagendayo emirundi 2 ng'agenda kugulira bano abantu emmere.
Also, this court notes that there was also evidence that as at the time of his arrest, he was not on the street. He had a home in Chanja, as testified by the landlord called Joel Mackay, who testified as PW10.
Nti ate we baamukwatira yali abeera ekyanja, ate n'omujulizi eyajja wano yali landlord we bamuyita Mackay, yali mujulizi wa 10.
In light of the above, the accused person failed to adduce any evidence to support this claim that he was not mentally okay on 2nd April 2026 when he gruesomely and brutally murdered the innocent infants.
nti n'olwekyo omuwawaabirwa alemereddwa okuleeta obujulizi okukakasa nti omutwe gwe gwali tegukola bulungi oba nga yali alina obulwadde bw'obwongo nga 2 Ogwokuna 2026 lwe yatta abaana abato.
The other probable defense that would be available to the accused person, given his from his testimony, would be a defense of diminished responsibility, and this one is provided for under Section 177(1) of the Penal Code Act.
Ekirala ekyandimuyambye kyakugamba nti yali obwongo obwo nga tasobola kutegeera bulungi bye yali akola.
And this one also, it is where a person is found guilty of murder or being a party to the murder of another, and the court is satisfied that the person was suffering from an abnormality of mind arising out of arrested or retarded development of mind. This relates to somebody who has a disease of the mind that has resulted into poor development of the mind, and that as a result of that, it takes away the person's mental responsibility.
Nti omuntu bw'aba nga omusango ogw'obutemu gumusinga naye ne basanga nga omutwe yali alina obulwadde bw'obwongo ate ng'obulwadde bw'obwongo bwali tebusobola kumukkiriza kubeera ng'ategeera ebyali bigenda mu maaso.
Even with that, the law provides in subsection 2 that if you raise that as your defense, it is you to prove that you are suffering from an abnormality of the mind.
Era amateeka gagamba nti bw'ogamba nti obwongo obwo bwali tebukola bulungi oba ng'olina obulwadde bw'obwongo olina okuleeta obujulizi okukakasa nti kyaliwo.
Looking at the evidence that the accused person adduced, there is nowhere he's talking about a retardation of his mind. The only issue that the accused person suffers from and was talked about by many witnesses is sickle cell disease.
Nti kusinziira ku bujulizi omuwawaabirwa bwe yaleeta teri kiraga nti yali alina obulwadde bw'obwongo kule okuggyako balaga nti yali alina obulwadde bwa nnalubiri oba sickle cell.
And when Dr. Agenda was asked as to whether sickle cell anemia is not an underlying cause for mental illness, he said it is not, but it is a risk factor.
Omusawo gwe bayita Agenda bwe yajja ne bamubuuza oba sickle cell eviiramu omuntu okufuna obulwadde bw'obwongo n'agamba nedda, naye muntu bw'aba alina sickle cell ayinza okukomenkerera ng'afunye obuzibu ku bwongo.
And he said this is as a result of too much pain and also the strength of the medication for sickle cells. But he hastened to add that when he was examining the accused person did not present any symptoms of the mental of any mental disabilities that may have been caused by sickle cell disease.
N'agamba nti ekyo kiyinza okuviira ku bulumi oba eddagala lya nnalubiri, naye n'agamba nti bwe yayogerera naye yali talina kiraga nti yali alina obulwadde bw'obwongo nga kiva ku bulwadde bwa nnalubiri.
Counsel for the accused vehemently argued that upon his arrest, the accused person was found with painkillers, which included diclofenac, and this court should find that this medicine was treatment for mental illness. But with all due respect, this argument is not supported by any evidence.
Prida yalemerako n'agamba nti bwe baakwata omuwawaabirwa yali alina eddagala oba makerenda ga painkiller nga diclofenac, naye tewaliwo obujulizi obukakasa ekyo.
No, he said that when he was arrested, he was found with painkillers. and the painkillers included diclofenac. This court should find that this medicine, the diclofenac, was used to treat a mental illness, was being used to treat a mental illness.
Nti bwe bamukwata yali alina painkiller nga diclofenac, kooti erina okulaba nti gano amakerenda oba yali agakozesa okujjanjaba obulwadde bw'obwongo.
And I said that with all the respect to counsel, this argument was not supported by any evidence, because even when he was asked what kind of mental illness the accused was treating, he had no answer to that.
Nti naye waali tewali bujulizi bwonna obukakasa nti yali alina obulwadde bw'obwongo ne bwe baamubuuza.
He said he did not know
n'agamba nti yali tamanyi bulwadde ki bwennyini bwe yali alwadde
that he was treating.
Bwe baali bajjanjaba.
In light of the above, I also find that the defense of diminished responsibility is not available to the accused person.
Okusinziira ku ebyo, wekitiibwa omulamuzi alaba nti okugamba nti obwongo obwo bwali tebuteredde nakyo tekisobola kumuyamba.
On the contrary, the prosecution adduced evidence to show that at all material times, the accused was of a normal mental status and in control of his actions, as will be discussed and analyzed below.
Oludda olwabi lwaleeta obujulizi obulaga nti buli kaseera omuwawaabirwa yali ali bulungi nga ategeera biki bye yali akola.
Prosecution adduced evidence of a sanity medical report which had been authored by Dr. Rogers Agenda. He's a psychiatrist at C-Care IHK.
Oludda olwabi lwaleeta alipoota y'obulwadde bw'obwongo nga omusawo gwe bayita Agenda Roger akolera ku ddwaliro lya IHK yagiwandiika.
This sanitary medical report was found in the house of the accused person during the search that was conducted on 3rd April 2026, and it was admitted as an exhibit.
Ate alipoota eyo baali bagisanga mu nnyumba y'omuwaabirwa bwe bagenda kwaza nnyumba ye nga 3 Ogwokuna 2026 era ne bagireeta mu kooti ng'ekizibiti.
And C-Care IHK verified it and confirmed it to be authentic, and Dr. Rogers' Agenda testified to it.
Nti era ab'eddwaliro erya C-Care IHK lyakakasa nti alipoota eyo yali ntuufu era ne basindika omusawo Agenda n'ajja n'agyogerera.
He testified that on 30th December 2025, he received the accused person as his client with a request to conduct a sanity examination and furnish him with a sanity report to be submitted to the Ministry of Internal Affairs, the Immigration Department.
Omujulizi oyo omusawo Agenda yagamba nti ng'ennaku z'omwezi 3 Ogwekumi-22, 2025 yafuna omuwawaabirwa ng'azze gy'ali n'amusaba nti amukebere obwongo oluvannyuma amuwandiikire alipoota nga yali agitwala mu Ministry of Internal Affairs ne Immigration.
He went ahead and did a psychiatric and mental examination on the accused person, and that report, the certified copy from C-Care IHK, was also admitted as an exhibit.
Nti era yagenda mu maaso n'amukebera obwongo oluvannyuma n'awandiika alipoota ne bamala ne bagireeta ng'ekizibiti.
According to him, the accused person presented himself as a 30-year-old single Christian by religion, resident of Bunga and self-employed mainly as a commercial farmer.
Nti yagamba nti omuwawaabirwa yamutuukirira n'amugamba nti yali wa myaka 39 nga si mufumbo, agamba nti yali mugoberezi wa Kristo ng'abeera Bunga ate nga yali mulimi nga byalima atunda.
He testified that he carried out a psychiatric interview which involves asking the client many times open-ended questions with the aim of establishing or enlisting whether the client has any mental disorder.
nti yatandika n'okumubuuza ebibuuzo ebingi ng'ayagala kulaba oba yali alina obulwadde bwonna ku bwongo.
Upon examination, the following were his findings. And I'm going to read them verbatim. He reports no history of excessive sadness or loss of interest in pleasurable activities.
Bwe yamala okumukebera n'agamba nti yali talina kiraga nti yali anyiizeeko nnyo nnyo oba n'okubeeraawo nga tayagala kwenyigira mu bintu eby'essanyu.
He has no history of excessive happiness or increased goal-directed activity.
Nti ate yali talina kiraga nti yali asanyuseeko ekisukkiridde oba okwagala kukola ebintu ebisukkiridde.
He has no history of alcohol or substance use, although he occasionally took alcohol.
N'agamba nti yali talina kiraga nti yali anywa nnyo omwenge oba kulya ebidagala.
He denies any history of hearing voices or seeing things others could not see.
N'ayegaana nti yali tawulira oba kulaba ebintu abantu abalala bye baali tebalaba oba okuwulira.
He has no history of excessive fears or worries and has never had a seizure.
N'agamba nti yali talabeerangako awo n'atya ennyo oba naye eraliikirira nnyo.
He denies any traumatic experiences and sleeps well.
Era yeegaana okubeera nga waliwo ebimutabula nnyo mu bwongo n'agamba nti yali yeebaka bulungi.
This is his index visit to a mental health personnel and has never been on any psychiatric medication.
Era n'amugamba nti gwali mulundi gwe gwali gusookera ddala okulaba omusawo w'obwongo era yali tamerangako amakerenda g'okujanjaba obwongo.
He is a known patient of sickle cell disease and regularly takes his medications.
Era bamumanyi nti alina obulwadde bwa nnalubiri era abadde ng'amira makerenda.
He has no other chronic medical conditions.
Talina bulwadde bulala.
He is the third born of 4 children.
Ye mwana w'okusatu mu maka g'abaana abana.
Both their parents are alive and well.
Abazadde baabwe bombi bwe bali ate bali bulungi.
There is no known mental history in the family.
Era tebamanyiiko omuntu yenna alina obulwadde bw'obwongo mu kika ekyo.
That was a psychiatric assessment. The mental status examination revealed the following, still by the same doctor. He is a middle-aged man who appears his age.
Era bwe yayongera okumwekebeza n'agamba yali omusajja eyali akuzeemu ate nga yali alabika emyaka gye.
He is well nourished and kempt.
Era yali alabika bulungi.
He is generally calm and keeps eye contact.
Nti yali mukkakkamu ate ng'asobola kusigala ng'atunula bulungi ng'alaba abantu wamu.
No odd behavior was noted throughout the interview.
Nti ate we yamwekebejjeza yali nga yeeyisa bulungi nga tewali we yali we yeeyisa bubi.
His speech is of normal rate, tone and volume, and is generally coherent and fluent.
Nti ate bye yali ayogera byali bikwatagana bulungi.
His thoughts are logical with no preoccupation over valid ideas or delusions.
Nti ate n'endowooza ye yali ekwatagana bulungi.
He has a euphemic mood congruent with affect and has no perceptual or cognitive disturbance.
Nti era byali akola byali bikwatagana n'embeera ze.
He concluded his diagnosis as follows. Onyum Christopher Okell has no established mental disorder. I therefore affirm that Onyum Christopher Okell is sane and mentally fit to live and work in Uganda.
Era n'amala n'agamba nti Christopher Okell Onyum talina bulwadde bwa bwongo, si mulalu, ate ng'asobola kubeera oba kukolera mu Uganda.
The prosecution also adduced the evidence of Dr. Nwamanya Emmanuel. That one is a police surgeon. He also did a mental examination on him on the 7th of April. This was now after the commission of this offense, 5 days after. And these were his findings. He had normal behavior, calm, cooperative, speech was coherent, his memory intact, and exhibited good judgment.
Baleeta obujulizi obw'omusawo gwe bayita Nwamanya Emmanuel wa poliisi era naye yamukebera obwongo ennaku z'omwezi 7 ogwokuna 2026 omusango guno gumaze okubaawo ennaku 5 n'agamba nti yali ategeera bulungi nga mukakamu ng'akwatagana naye bulungi ng'ayogera bulungi ate ng'asobola okumanya ekituufu n'ekitali kituufu.
Okay. His thought process and content was normal, but he believed in wealth by human sacrifice.
N'agamba nti yali alowooza bulungi naye nga yali akkiririza mu saddaaka.
He was able to explain the reasons for killing the children as fortune hunting or enrichment.
Nti yamugamba nti ensonga lwaki yatta abaana yali ayagala kufuna bya bugagga.
He got the idea on recalling childhood folk tales of getting wealth by sacrificing people.
Era ekyo yakijja ku ngero ze yawuliranga ng'akyali muto ez'okusaddaaka abantu okufuna ebyobugagga.
The accused person, his testimony, stated that from January to March 2026, he underwent distress and encountered people who influenced his actions of 2nd April 2026.
Omwawabulwa yagamba nti wakati wa Januari n'ogwokusatu 2026 yali mwenyamuvu olw'ensonga y'abantu be yasinkananga ate ng'agamba be bavunaanyizibwako bye yakola nga 2 ogwokuna 2026.
I find this move by the accused person very calculated because he smartly targets a period immediately after his sanity and mental examination done on 30th December at IHK at his own request and instance.
N'agamba nti kirabika bino omwawabulwa yabibala kubanga yalaba ekiseera ng'amaze okugenda okumukebera obwongo mu mwezi gwa December 2025.
Now I'm saying that the accused person is smart. He brings the period after the examination so that we don't know what happened after the 30th of December.
Yali mugezi nnyo era n'akibala n'agenda n'akola bino nga
he intelligently and smartly supposes that his distress happened after that examination, which would mean therefore that the distress after 30th December is the reason for his actions of 2nd April 2026.
Yali mugezi nnyo n'aleeta ensonga y'okugamba nti yali mwennyamivu wakati wa Januari n'ogwokusatu 2026 nga bamaze okumukebera 3 ogw'Ekumi 2025 n'agamba nti ebyo bye byamuviirako bye yakola nga 2 ogwokuna 2026.
He also smartly and intelligently brings this period of his alleged distress to fall before his next psychiatric and mental examination that was done on 7th April 2026 by Dr. Nwamanya Emmanuel on Police Form 24.
Era yaleeta ekiseera kino kye yali mwennyamivu nga ebbanga lye yayogera yali nga tannatuusa we bamukeberera nga 7 ogwokuna 2026.
In light of the above smart move by the accused person, this court will proceed to examine and assess his conduct and lifestyle between January and 2nd April 2026 when he committed the offense to determine whether or not he was mentally functional.
Olw'ensonga nti yakola ebintu bino mu ngeri y'amagezi, kooti egenda kutunuulira engeri yeeyisaamu wakati wa January ne 2 ogwokuna 2026 okulaba oba omutwe gwe gwali kukola bulungi.
The evidence of Mr. Paul Mukasa Paul he was CW9, and he was the landlord of the accused person in Bunga for a period between November 2025 and March 2026. And he testified that while he was renting his house, the accused person was a very good person, relating well with others, and that he did not notice anything odd or irregular with his conduct.
Oludo lwabi lwaleeta omujulizi gwe bayita Mukasa Paul eyali landlord w'omuwawaabirwa ebbunga n'agamba nti yali landlord we kuva nga ogw'Okumi-na-gumu 2025 okutuusa nga ogwokusatu 2026 era n'agamba nti bwe yabeera ku nnyumba ye yali muntu mulungi nga yeeyisa bulungi ate ng'akwatagana bulungi ne bamuliraanwa.
According to the evidence of Makai Joel, now that's the landlord of Chanja, where the accused person was staying at the time of this offense, the person approached him for a house to rent. The accused person approached him for a house to rent on 16th March 2026, and he came with a broker.
Era waliwo omujulizi Makai Joel ono yali landlord we ekyanja era nga yagendayo ne buloka ewuwe ng'anoonya ennyumba nga 16 ogwokusatu 2026.
The accused entered into a transaction with him to rent a house for 4 months. He was informed that the monthly house rent was 400,000, and he was supposed to pay 4 months up front. And the accused was further informed that payment was supposed to be made in the bank. The accused then requested for the bank account details, after which he went and paid in the bank and returned a bank slip to the witness.
Nti era bwe yatuukayo ng'anoonya ennyumba n'akkiriza n'awandiika endagaano ng'agamba nti apangisiza emyezi 4 ne bamugamba nti buli mwezi ajja kusasula $40,000 ne bamugamba nti ezo ssente alina ozisasula mu banka era n'abasaba banka akawunti ezikwata ku banka ne bazimuwa n'agenda mu banka n'asasula ssente n'aleeta n'akapapula ke yasasuliddeko.
From this evidence, this court finds that at this point the accused person was in very good health, mentally functional, and in control of his actions. Otherwise, how would he even know that he needed a broker to get a house, or how would he know how to make payments in the bank?
Kkooti egamba nti akaseera ako yali bulungi nga n'omutwe gwe gutegeera bulungi kubanga yategeera atya nti yali yeetaaga bulooka okufuna ennyumba n'ategeera nti alina okugenda ne mu banka kusasula ssente.
The prosecution also adduced the evidence of Hashim Juma, the director of Trip Car Rental Uganda for Self-Drive, who testified that the accused person first contacted his company via the business WhatsApp number on the 12th of March 2026, and he was inquiring about their car hire services.
Era baleeta omujulizi gwe bayita John Hashim Juma nga yali wa Trip Car Rental nga ono yabatuukirira ku WhatsApp n'abasaba emmotoka ng'agenda kugyevugira era yabatuukira nga 12 ogwokusatu 2026.
The accused was using an American number, and he told the witness that he needed the car the next day. The next day, the accused called the witness and told him he was already at the meeting location, but because he had not confirmed, the witness, that is Juma, was not there. He had not reached, and when he reached, he found when the accused person had already left. This was at the Freedom City Mall.
Nti yali akozesa enamba ya Amerika era n'amugamba nti yali yeetaaga emmotoka olunaku oluddako era yatuukako nga Juma yali tannatuukawo era bawo n'agenda ate awo waali City.
Okay, then the accused contacted the witness again on 14th March and said that he had left because he was rushing somewhere and couldn't wait, but he would rent the car the following week.
Era omwawazibwa yaddamu n'amugamba nga 14 ogwokusatu n'amugamba nti luli yali amuleseewo alina gye yali agenda n'amugamba nti ayagala emmotoka ayagala gikozesa wiiki eddako.
I am giving all this detail because I'm trying to show the conduct or the actions of the accused person during the period he says he was in distress.
Ali mu kusoma bino byonna musobole okutegeera ebyo yali akola mu kiseera kye yali agamba nti yali mwennyamivu.
The accused person contacted the witness again on the 31st of March through a WhatsApp and told him that he needed to rent the car again for 2 days, that is 1st April and 2nd April 2026.
Era ng'asatu mu lumu ogwokusatu 2026 yaddamu n'amusindikira WhatsApp n'amugamba nti yali ayagala kukozesa emmotoka kumala ennaku 2 nga lumu ne 2 ogwokuna 2026.
The witness then offered to deliver him the car that evening of 31st March, which the accused was agreeable to. The witness then requested for directions of the location, and he was informed that it was in Chanja. The witness further asked for a Google PIN, which the accused person provided, and following the Google PIN, the witness was led directly to the house where the accused was staying in Chanja.
Era omujulizi yamugamba nti asobola kumutwalira motoka, omuwawabirwa n'akkiriza n'amugamba nti agimuleetera ekyanja. Ono kwe kumusaba PIN oba ekimulugaga gy'ali, era bwe yagimusindikira n'emutwala n'emutuusa ku nnyumba gye yali.
The accused person received the vehicle and also gave the witness his American passport and American driving license for his identification. The witness took photographs of them and handed them back to the accused person. And the accused asked for the mode of payment. He was told that he could pay with mobile money, and he transferred 388,000 shillings for car hire for 2 days on self-drive.
Nti era emmotoka yagifuna n'amuwa passport ne pamiti. Omujulizi n'abikuba ebifaananyi n'abimuddiza era n'amubuuza oba asobola kusasuza mobile money, oli n'akkiriza n'amusindikira emitwalo 38,800.
The witness further testified that during his interaction with the accused person, both online and physically, the accused did not present any abnormal behavior. According to him, a person of unsound mind would not have transacted with him the way he did. That the accused person, if he was of unsound mind, he would not have been able to transact online, use mobile money, would not have been given a driver's license, among others.
N'agamba nti akaseera ke bayogerezaganya wamu yali talaba ennyisa yonna etali ya bulijjo. N'agamba singa yali tategeera bulungi, yali tasobola kukozesa mobile money, yali tasobola kubatuukirira ng'abasaba motoka.
He also testified that later in that night, the accused person called him asking for the car keys because he had forgotten to give them to him when he delivered the motor vehicle earlier in the evening. The witness told him that he sent the keys with a border rider, and as early as 7 a.m. on 1st, the border had delivered the keys. He was even able to direct the border to where his home was in Chanja.
Era oluvannyuma ekiro yakubira kumubuuza waye gye yali atadde ebisumuluzo kubanga oli yali yeerabidde ebisumuluzo, n'amugamba nti agenda kumusindikira wa boda ku makya, era essaawa emu ez'okumakya ebisumuluzo baali babireese nga yamukubira n'amulagirira wa gye yaali.
On 1st April 2026 at around 11, the witness testified that the accused called him and told him that the car had mechanical issues, and when he asked his location, he told him he was in Bunga and he sent a mechanic to fix the car.
Nga lumu ogwokuna 2026 ssaawa 5 nti omuwawabirwa yamukubira ng'amugamba nti emmotoka yali efunye obuzibu, n'amubuuza wa gye yaali, n'amugamba nti yali Bunga, kwe kumusindikira makanika.
After about 1.5 hours, the accused person again called the witness and told him that he was at Ginger Road roundabout, but informed him that the car had failed again.
Era oluvannyuma lw'essaawa emu mu kitundu yaddamu n'amukubira n'agamba nti yali ku roundabout ye Ginger Road ate ng'emmotoka yali yazzeemu okufuna obuzibu.
The witness then advised him to drive it to Shell Ginger Road and park the car there, which the accused person did.
Era n'amugamba nti emmotoka agivuga alitwale ku Shell ku Ginger Road, n'agivuga n'agitwalayo.
I examined the WhatsApp communication between the accused person and the witness regarding the hiring of the motor vehicle, which was extracted and incorporated in the digital forensic examination report. And I have found that the conversation between the accused person and the witness regarding the car hire was very accurate and coherent.
Oweekitiibwa omulamuzi atunuulidde bye baayogerako nga bali ku WhatsApp ebikwatagana ku kupangisa emmotoka ate nga babiwandiika mu alipoota gye baleeta mu kooti n'akakasa nti okusinziira gwe baali boogera omuwawaabirwa nti yali ayogera bulungi nga gye yali ayogerako byali bikwatagana.
The accused person clearly knew what he wanted, clearly directed the witness to his home at Namugera Close in Chanja, and even went ahead to give more details that where he resided, that it was the first gate on the left side, and that he had told the custodian to wait for him because it was raining.
Nti yali amanyi nti yali yeetaaga kubanga yamugamba nti yali abeera Chanja era n'amunnyonnyola bulungi gye yali abeera ng'agamba nti yali geeta esooka ku mukono gwa kkono n'amugamba nti yali ataddeko omuntu akumulinda.
In addition to that, the accused person provided a Google pin to his location.
Nti ate okwongereza ku ekyo yamuwa ne pin eraga wa gye yali.
The accused person was actually in total control of his actions and was very mentally functional, because his communication was not only coherent but also systematic and logical, and had a very good sense of judgment, which negates his claim of being under immense distress during this period that prevented him from understanding the nature and quality of his actions on the 2nd of April 2026.
N'agamba nti byonna bye yakola byali bikwatagana nekiraga nti yali talina bulwadde bwa bwongo nga bwe yagamba nti yali mu kwenyamira mu biseera ebyo ate nga kyekyamuviirako okukola bye yakola nga 2/4/2026.
Okay, the prosecution also adduced the evidence of Odongo Emmanuel. This is the CCTV analyst, whose evidence reveals the movement of the motor vehicle raffle from Chanja on the day on 1st of April, and it stopped through Nakawa and Kabalagala Kansanga until it parked at Renewal Circle.
Nti era baleeta obujulizi obwa Odong Emmanuel ono yaleeta obujulizi bwa zikamera n'agamba ng'alaga emmotoka ekika kya RAV4 bwe yatambula okuva Chanja nga lumu ogwokuna 2026 n'eyitira Nakawa n'egenda Kabalagala n'egenda Kansanga paka bwe yatuuka ku Renewal Circle.
At Renewal Circle, the accused person was captured by a private camera of the said circle as he parked the vehicle. He found other vehicles already parked in the yard, and he maneuvered and found a suitable parking slot for his vehicle. As the accused moved out of the car, he checked the door to confirm that he had locked it. Upon his return, the accused checked the left front tire of the motor vehicle.
Nti ku Renewal Circle kamera zaamukwata nga aparkinga w'emmotoka ye, yatuuka n'asanga nga waliwo emmotoka endala nnyingi ezaali zipaakinze, naye n'agezaako n'afuna ekifo ky'okupaakingamu emmotoka ye. Bwe yapaakinga n'akebera oluggi okulaba oba yali alusibye, era bwe yavaamu n'akebera n'omupiira ogwa kkono ogw'omu maaso.
Is this conduct of a person who is suffering from a disease of the mind to prevent him from understanding
obulwadde bw'obwongo kyasobola okukola ng'agamba nti obwongo bwe tebukola bulungi ate nga bye yali akola yali tasobola kubitegeera?
I answer this question in the negative and make a finding that the accused person was in full control of his actions and with proper sense of judgment.
Era oweekitiibwa omulamuzi n'agamba nti mu butuufu bw'oba yali asobola kutegeera biki bye yali akola ng'asobola kwawula ekituufu n'ekikyamu.
And the prosecution also adduced evidence of his leaving Renewal Circle up to the point at Shell where he parked the car because it had a mechanical problem.
Era baleeta obujulizi obulaga engeri yava ku Renewal Circle n'avugira ddala n'atuuka ku Shell gye yali apaakinze emmotoka olw'okuba nti yali afunye obuzibu.
The accused person was seen pushing the vehicle being assisted by the staff of Shell.
Era baamulaba ng'asindika emmotoka ng'abakozi ba Shell bamuyambako.
And also making phone calls.
Era ng'akuba masimu.
And the PW8, the owner of the car, the one who had hired the car to him, confirms that while at Shell they talked on phone.
Era eyali amuwadde emmotoka yakakasa nti bwe yali ku Shell bayogera ku ssimu.
So my conclusion on that is that he was in control of whatsoever he was doing, and he had a good sense of judgment, since he could even tell that the car has a mechanical problem and knew who to call to solve it.
Nti n'olwekyo oti omulamuzi agamba nti yali ategeera bulungi ng'asobola kutegeera biki bye yali akola.
I also now go to the events at the gate of the center, that is the scene of crime, of 1st April 2026, when the accused went and stood at the gate and had a conversation with PW6, that is Phoebe Namutebi.
Era agenda kwogera ku byaliwo ku geeti nga lumu ogwokuna 2026 omuwawaabirwa bwe yagenda ku geeti n'ayogera ne Phoebe.
PW6 testified to the conversation that she had with the accused person regarding the enrollment of his child.
Phoebe yajja n'agamba nti bayogera nga boogera ku ky'okukwatagana n'okuleeta omwana kuwandiisa omwana mu ssomero eryo.
Yes, he said he had a child who was 3 years, and when he was told that they don't take 3 years, he should take to the nursery section, he said he had tried, but he had been advised to take his child to a place where there are other children, because she was not social and she would learn with the many children.
Nti era yagamba nti omwana gwe yali agenda kuwandiisa yali wa myaka 3, ne bamugamba nti bo bali tebawandiika ba myaka 3, ne bamuwabula nti omwana mutwale mu bannasale. N'agamba nti yali agezezaako okumutwala mu bannasale ne bamugamba nti amutwale awantu awali abaana bangi olw'ensonga nti yali takwatagana bulungi n'abantu abalala ng'asobola kukwatagana bulungi n'abantu ng'abadde n'abaana abalala.
He went ahead to propose to Phoebe that when he is allowed to enroll the child, Phoebe should monitor the child for him, and when she picks up, then he can take her to a nursery section.
Era yagamba Phoebe nti bw'aba aleese omwana asigale nga mumulabirako amulaba nti bw'amala okubala nga asobola kukwatagana n'abantu abalala amutwale mu nursery.
We then asked Phoebe what was required to enroll this child, and Phoebe told him all the requirements, and he promised to return the next day to make payments.
Era yabuuza ebyali byetaagisa okuwandiisa omwana. Phoebe n'abimugamba n'agamba nti agenda kukomawo enkeera okusasula.
On the next day, which is the date of the incident, the 2nd of April 2026, the accused person returned to the gate of the center.
Na 2 ogwokuna 2026 luno bino byatuukako ku olwo omuwawaabirwa yakomawo ku geeti y'essomero eryo.
And when Phoebe saw him, she went to him and he told her that he had come to make payments so that his child could be enrolled at the center.
Phoebe bwe yamulaba n'agenda ku geeti. Bwe yatuukawo omuwawaabirwa n'amugamba nti yali azze okusasulira omwana atandike.
Phoebe then took him and introduced him to Miss Annette, PW7, and they also engaged in a deep conversation regarding the child.
Phoebe yamutwala n'amwanjulira Annette, era bwe yatuukayo era ne basigala ne boogera ku byali bikwata ku mwana oyo.
The detail of the conversation is in the judgment, but it shows a coherent person who was in control of his actions and his speech and did not present any odd behavior to Miss Phoebe and Miss Annette.
Byebayogerako ebisinga babiwandiise mu nsala y'omusango naye biri nti bwe bayogera wamu yali yeeyisa bulungi ate nga bye yali ayogera byali bikwatagana bwe yali ayogera ne Annette ne Phoebe.
And when he asked for the requirements and he was told 120 for daycare fees, 60 for uniform and 10,000 for registration, he mentally calculated that before Miss Annette could use a calculator.
Era bwe bamugamba ebyali byetaagisa nga bamugamba emitwalo 12 za daycare, emitwalo 6 egya uniformu, omutwalo gwa kuwandiisa mwana, yabibalirawo mu mutwe gwe n'abagamba nti gyali mitwalo 19.
It is shortly after that interaction, a very normal, coherent interaction, that when he moved out, he launched this brutal and fatal attack on the defenseless, innocent children.
Bali baakamala okwogera bulungi n'abakyala abo n'amala n'afuluma n'atuuka mu baana n'atandika okubakirimbula.
It is the finding of this court that at the time of the attack, the accused person did not suffer from any disease of the mind. He was in full control of his actions.
Era kooti esanze nti akaseera ako we yattira abaana abo yali amanyi kye yali akola.
And Miss Phoebe, the PW6, testified that this event, the act of slaughtering these children, took about 7 minutes, and I can believe her because looking at the time when he sent the money on Miss Annette's phone to the time when he made a phone call, an emergency helpline of police, is a very short time. It is actually 14 minutes. So it is not possible that at the time of catching the children is when he lost his control due to any disease of mind.
N'agamba nti Phoebe yagamba nti ebintu byonna bino byatwala eddakiika nga 7 ate kooti emukkiriza kubanga etunuulidde mu kaseera ke yasindikiramu essente ku ssimu ya Annette ne kaseera kwe yakubira poliisi kyatwala eddakiika 14 era kooti egamba nti tayinza okuba nga we yakoma okutegeera okugamba nti abaana bano yabasala nga tategeera.
Of course, I have taken note of the arguments for counsel for the accused person, that the center management was criminally negligent because they had no guard at the gate and they left the children unattended to, which led to their death. But I find this argument quite insensitive because the children were in their familiar space and it was never expected that someone would enter the center premises disguising himself as a potential parent only to do what the accused did to the innocent children.
Lawyer w'omuwabirwa yagamba nti essomero lyali lagajjavu olw'ensonga nti baali tebalina mukuumi nga baana tebalina omuntu eyali nabo naye bagamba nti abaana baali bamanyidde ekifo kino ate baali tebasuubira nti omuntu ayinza okujja ng'omuzadde ate n'akosa abaana.
Besides, during this fatal attack on the innocent children, PW6 and PW7, that's Miss Phoebe and Miss Annette, they testify that when they saw him cutting the children and came to intervene, he threatened to cut them as well. Yeah. And then, when he saw himself in danger of the crowd that was angry, he had the mental ability now to call police for preliminary interview with SP Esserite James, where he informed the witness that he was staying in Chanja and that he had bought knives and he had the mental ability to take the search team to his home, moreover rented premises where he had been for less than 2 weeks, but he could locate that home. And indeed, during the search, the knives were found, new knives, and they were admitted as exhibits.
Nti era nga bakamukwata yayogerako n'omupoliisi gwe bayita Esraite James n'amugambirawo nti yali abeera akyanja era n'amugamba nti yali aguze obwambe era ye kennyini n'atwalayo abaali banoonyereza omusango n'abatuusayo wadde yali akabeerayo weeks 2 bwe baamala okwaza ennyumba era ne basangayo bwambe nga bupya.
I have also found it necessary to, in this judgment, examine the lifestyle and or actions of the accused person before this offense to establish whether he was mentally functional or not. And I looked at the bank accounts. The accused person had 3 bank accounts, $2 accounts, and 1 shillings account, Uganda shillings account. And I have analyzed the bank account statements, and I find that he was transacting normally on these accounts.
Era okiba omulamuzi alabye eneyisa y'omuwabirwa nga bino tebinabeerawo n'asanga nga yali alina akawunti mu banka, yalina akawunti 3 mu banka nga akawunti 2 zaali za dola ne akawunti emu ng'ateekako siringi za Uganda, n'alaba nti yali akwasaganya banka zino ng'omuntu owa bulijjo.
He is able to transact from wallet to account, from account to wallet, is buying, is paying, withdrawing money for paying rent. He actually also withdrew money for hiring farmland. And during the search, there was an agreement for a lease, a hire of land in Noya for farming. This accused person, who wants this court to believe that he was mentally ill, is making investment decisions.
Nti ku banka ezo yali asobola kujja ssente ku akawunti n'ateeka ku simu, n'ajja ku simu n'ateeka ku akawunti n'ajjayo ssente, era yajjayo ssente ez'okupangisa ennyumba, ez'okupangisa ettaka lye yali agenda kulimirako ennoya, era nti bwe yazza ennyumba ye baasangayo endagaano y'okupangisa ettaka mu nnoya, era nga y'omuntu omu agamba nti kkooti ekkirize nti yali tategeera bulungi so ng'ate yali asiga nsimbi.
The prosecution also provided evidence of Google searches that the accused person conducted on his phone, and I have found them relevant to this case.
Era baleeta obujulizi obulaga nti yakebera ku Google ng'akozesa essimu ye ate kkooti esanze nga bikwatagana n'omusango guno.
PW18 led evidence the effect to the fact that the accused devices, the laptops and phones, indicated that the accused had made searches about schools near me.
Omujulizi ono ow'okunamunaana yagamba nti bwe baakebera amasimu ge n'ezi laptop byalaga nti yali anoonyerezaako ku masomero agaali kumpi naye.
And among the schools that he searched among the places that he searched is Church Close Gaba.
Ate mu bifo bye yanoonyerezaako mwalimu Church Close e Gaba.
And the center where this unfortunate event happened is on Church Close Gaba.
Ate essomero bino we byatuuka liri mu Church Close e Gaba.
Other items searched were rental hours of operation Trip Car Rental Uganda, and we have evidence of him hiring a car from Trip Car Rental on self-drive the day prior to this unfortunate incident.
Era yanoonyereza ku Trip Car Rental nga bano be yafunako emmotoka n'agipangisa ng'agenda kugyevugira era gye yakozesa.
He's also searching how many kilometers does 14 liters get on a RAV4. He's searching about Bunga Police Station. He's searching about ISIS beheading. And And he's also searching about firearm license in Uganda.
Era yanoonyereza ng'abuuza lita 14 mu RAV4 zimutwala kutuuka wa, n'anoonyereza ku poliisi y'ebbunga, n'anoonyereza ku ISIS beheading oba ekitongole kitemako emitwe gy'abantu, n'anoonyereza omuntu afuna atya license y'emmundu mu Uganda.
Okay, and I have also noted that the accused person denied having conducted these searches in preparation for this crime, but I reject his claim because whereas the way he hacked or he slaughtered the children is how I take judicial notice that ISIS is Islamic State of Iraq and Syria. It is a widely recognized by international governments and organizations as a major terrorist organization, and is known for committing atrocities, including genocide, public beheadings, and conducting targeted violent attacks. I have no doubt in my mind that the search for ISIS beheadings prepared the accused person to launch this fatal attack on the defenseless children. As already observed and clearly stated by PW6, the attack that led to the death of the 4 infants took less than 7 minutes. It is only a person with specialized training in beheading and the heart and mind of a terrorist that would do what the accused person did. It is my further finding that this very specialized training and meticulous planning and premeditation strongly negates any claims of insanity.
Nti omuwawaabirwa yagaana nti bino okubinoonyerezaako yali tateekateekera okuza emisango gino, naye kkooti n'eraba nti yanoonyereza ku ICC ate nga kino kyekitongole ekisinga ekyabayeekera nga bakola ebintu bingi, batta abantu, basanjaga mu lujjudde, n'agamba nti bino biyinza okuba nga bye byamuleetera okulumba abaana bano abato n'abatta. Ate omujulizi ow'omukaaga yagamba nti bino ebintu byonna byaliwo mu ddakiika nga 7, ekitegeeza omuntu eyakola ekintu kino yali mutendeke bulungi okukola ekintu kino, ate mu kupulaninga kino kiraga nti omutwe gwe gwali gukola bulungi.
I have labored to analyze all the above evidence to rule out any claims by the accused person or any other person that may believe his claim of insanity as his defense to run away from accounting for this heinous crime.
Oweekitiibwa omulamuzi agezezaako nnyo okulaba nti alaba obujulizi, ate ne kiraga nti omuwawaabirwa yali talina bulwadde bw'obwongo, ekitegeeza nti yaleeta ekyogamba nti obulwadde bw'obwongo ng'ayagala.
Interpret that well. I have labored to analyze all the above evidence to rule out any claims by the accused person or any other person that may believe his claim of insanity as his defense to run away from accounting for this heinous crime.
Nti oweekitiibwa afubye nnyo okulaba nti alaba obujulizi obwaleetebwa okulaba nti omuwawaabirwa yali talina bulwadde bw'obwongo, ate teri muntu asobola kugamba nti yali alina obulwadde bw'obwongo. Oba omuntu yenna okulowooza nti yali alina obulwadde bw'obwongo ng'agezako okudduka obuvunaanyizibwa bw'ekintu kino ekyatuukawo.
Having done that, I conclusively find that the accused person was very sane on 2nd April 2026 when he gruesomely slaughtered 4 innocent souls.
Nti oweekitiibwa omulamuzi agamba nti nga 2 Ogwokuna 2026 omuwawaabirwa yali ategeera bulungi okutta abaana bano bato be yatta.
Therefore, neither the defense of insanity nor diminished responsibility is available to him.
n'olwekyo ekyokugamba nti omutwe gwe gwali tegukola bulungi oba yali alina obulwadde bw'obwongo tebimuyamba.
On the contrary, I find an agreement with the joint opinion of